evening. This is the Hingham Zoning Board of Appeals. The date is November 30th, 2016. It's 7:05 p.m. And for purposes of the open meeting law, the board is recording these proceedings. And I also note that the proceedings are being filmed by HCAM. The first item on our agenda is a continuation hearing for Broadstone Bear Cove Alliance LLC, which is a continuation from our hearing on November 9th, 230 Beal Street. This is an application for a comprehensive permit. It was originally filed to construct to build a 300-unit rental community, including 75 affordable housing units on approximately 12.06 acres of land located in the Office Park zoning district. They have subsequently amended their filing, so they are now seeking to construct a 220-unit rental community. Who is here for the applicant, and who would like to make the initial presentation?
I am Jeff Toccio here for Alliance Residential, and Carlton Quinn from Allen & Major Engineers is with me to my left, and then Scott Golding from my office. What we understand this evening on the schedule will be to go through some of the civil engineering issues, drainage, et cetera, and I understand and I know that Patrick Brennan's here from Emory, the review engineers, and then also Carlton's here with me today if there are any questions we need to follow up. Since our last meeting, what I've done is followed up on several outstanding items. One was the confirmation of the hard 220 unit count. Yep. You folks had asked us to confirm that in writing, that it wasn't then going to be 220 with an additional 10% on top of that, and that was submitted to your agent some weeks ago. Also, the fiscal impact response, there were some comments with respect to that, and that was updated to match some of the updated assumptions, and that was submitted to you folks. Additionally, Mass Historic Commission, Brona Simon, did issue a letter to your board having to do, if you haven't seen it, I did just see it, and I know that Andrea Young just, I think, received her CC today, so perhaps that's in the mail, but that submission should be there, basically saying that they went through, they received all of the PAL documents, and that there were no further follow-ups. And then we did submit further summaries and information with Historic, and I believe if you don't have it today, you'll have it tomorrow. And then also what happened was Allen & Major did issue a response letter on November 21st. So when Patrick goes through some of his comments, there is a follow-up to that where we can discuss some of the comments, or certainly if Pat wants to discuss what the follow-ups are, they can do that as well. And then also, just today, we did update the waiver requests, and what we did was get those up to date as of the last submission. I'm not sure if they require further update, but of course, plans will be updated to match with some of the comments on the civil engineering. And then we did also add information specifying where the area of specific waivers sought occurred. So for example, instead of having 20 feet of setback on a certain line and there's 16, we'll identify that was along the northern property line where the fields are. So if there are any questions, if you want any follow-up, we can certainly give you more detail on that. And that's a good summary, I believe, as of now, of where we are.
It is. I mean, just getting back to the waiver point,
Yep.
One of the things that this board would be insistent on is, to the extent that you're looking for a waiver, it is limited to the specific area. And for example, the 20-foot is not just a general waiver of that, it's for the specific location. So I appreciate your willingness to present that information. Emily, before we proceed, is there any other steps that we should take at this point?
Yes, we did receive public comments submitted by Attorney John Whitten on behalf of Back River Condo Trust just today. The board members have received that.
And do we have Susan Murphy here, who is the town's real estate counsel? Susan?
I just have a request. Can I get a red line of the waiver
Absolutely, yes.
Okay, thanks.
And then I do have, I'm sorry, November 18th, so I do have copies of Mass Historic's letter, and I can just give that to you this evening as well.
I was going to ask her about it as well, so thank you for...
Okay.
Swing that around over to Emily, so you can stamp it in.
Any other questions? No.
I issued a final one on the 29th. That one was a draft.
Oh,
I don't
okay.
think it's a big deal.
And the Allen and Major, I gave you a draft date, so it was the 29th of November, not, I think I had said before, the 21st. So the date of that is the 29th.
Okay.
Thank you.
So who is your lead-off speaker?
I think that I'm going through looking for efficiency rather than reopen. We did make a presentation at least one of the earlier hearings. The thinking was that if Mr. Brennan is prepared to go through his comments, it was very, very comprehensive. And what he's done is he's copied the original comments, responses.
Right, I saw
So
that.
that might be the most efficient way to do it if that's
That makes sense.
good for you.
I haven't seen this.
Thank you, Mr. Chairman. For the record, Pat Brennan with Amory Engineers. I'm the zoning board's consultant engineer on this project for the site civil engineering aspects of the project. I submitted a letter to the board on November 17th with a number of comments. Subsequent to that letter, as Attorney Lisi alluded to, yesterday I received a response letter from Allen and Major responding to my comments. And basically, they submitted the letter, but there was no documents. It's my understanding that they're going to submit revised plans and calculations
Right.
after everything's kind of out on the table so that they can do one final submission of the revised plans. As I go through the letter, and I'm going to be going through kind of the Allen Major response letter because it lists my comments as well as their responses. I think that's the most efficient way to do it. And I can, I'll just kind of hit on each one and give a quick little synopsis of where we're at with it.
And just when you say your letter, it's the November 17th.
Correct. But I'll be going through the Allen and Major, the November 29th
Yep.
letter. So, under general comment, comment 1 was just that I believe that their application was complete. Comment number 2 related to their waiver requests. 2A was regarding the height of the building. With that revised waiver request letter that they submitted today, they addressed that and put the actual height of the building in there. 2B was in relation to parking. Again, with the revised waiver request letter, they clarified that some. Originally, I had 2 issues with it. There's a drop-off area in front of Building 2, which only had a 20-foot wide drive aisle with nose-in parking spaces. Your requirement is for a 24-foot wide drive aisle. To my understanding, after talking with Mr. Quinn today, that the drive aisle behind the parking spaces will have 24 feet of width, but it's going to narrow down to 20 feet, basically where you consider it curb cuts, where it will go back out to the other drive. So I think it'll comply in that respect, because you have the 24 feet behind the parking spaces, which is what the regulation is looking for. So their request now is for less than 2 parking spaces per unit, and in both parking garages under the buildings, they do have 24-foot wide aisles, but they only have 18-foot long spaces. Your regulation allows 18-foot long spaces if you have a 2-foot overhang. They do not have the 2-foot overhang in the parking garages, so that's where the other part of that waiver is. Number 3 was about the parking summary. They said that they have addressed that on the revised plans, and we'll wait to see on that. The 4th one was with regard to retaining walls. They're showing retaining walls on both driveways that go down into the parking garages. I had 2 comments. Any retaining wall over 4 feet high requires a building permit, and they've acknowledged that. And also, I asked that they put some type of a fall protection device on top of each of those walls They did acknowledge it for building number 1, and I reminded Mr. Quinn today that they also needed it on the northwest corner of building number 2. There's a retaining wall there that they need a chain, they're gonna do a chain link fence on that as well.
Before you go on, just go back to point number 3.
Yes,
And that had to do with the number of parking spaces?
yes.
Do we know what the correct numbers are?
It is. 338 total, with 206 of them in the garages.
Okay.
And that equates to their I believe it's 1.54, yes. And that number equates to that.
Jeff, are you in agreement that that's correct?
We are right. Those are the numbers?
That's correct, and that was shown on the architectural plans of what we submitted. It was just a typo on the civil
Okay.
plans.
So again, on number 4, they've agreed to call out a chain link fence on top of that other retaining wall also. And they've also said that they will submit the retaining wall designs with building permit for each of those. Number 5 was a comment on the thickness of the pavement, and they've said that they will agree to that, make it a little bit thicker. Number 6, there was clarification needed to be made on the plans where they called out crosswalks at different widths and different locations, and they said that they've revised all of them to be 8 feet wide. Number 7, I had some questions because there really wasn't any information provided. There's an existing stump burial area shown on the plans where there will be a driveway and some parking going across that. There are no utilities in that area proposed. Their response, they gave me kind of the information I was looking for. I was mainly asking if they've had the area evaluated to verify that it will adequately support the driveway and the parking spaces on top of it. In their response, they said that they have had a geotechnical engineer review that to ensure that it is adequate to support that infrastructure. So as long as they've done that, I'm satisfied with that. Number 8 was, I've asked for a hydrant, or asked them to demonstrate that they have adequate fire flow. They've responded saying that they've got a hydrant flow test scheduled December 6th, next Tuesday, to determine the capacity of the water main in Beal Street. Another part of that comment, I suggested that they maybe loop their water main back out to Beal Street, either using the existing water main that's on site or a new loop, and they said that they have shown a new loop on the revised plans. Number 9 was just, I was just saying that we're assuming that they're working with the fire department, and they have confirmed that they are working with the fire department regarding the number of hydrants, locations of hydrants, building connections, and the fire department access.
Let me just stay on that. Jeff, how far are your discussions with the fire department on that?
They're at a point where I think we've met perhaps 3 times, going through different issues. Where we are right now is that they're waiting for any further details. I think we're starting to get into the point where they look at building permit and what the specifications are going to be. But we've been through detail as far as the NFPA regulations, et cetera. We got some really good feedback, and I think so far we're on target with all of their requirements.
Okay, so they've not raised any red flags with you?
Oh, correct.
Okay.
Anything that was raised was addressed months ago.
Okay.
Okay. My next comment was in relation to the emergency fire lane behind building number 2. There was a conflict between the civil plans and the landscaping plans on the type of surface. They've clarified that, or they say they have on the revised plans, and say that it will be a porous asphalt surface. Comment number 11 was regarding your zoning bylaws require a site lighting plan. They have responded saying that they're working on that, and they will provide that site lighting plan. So that's something that will need to be reviewed once that's provided.
Let's just,
About a week that's been around.
I just want to stay on the lighting for a minute. And one of the things that would be of concern to the neighbors is to make sure that the lighting is appropriate in terms of not causing light pollution, but also ensuring safety. So Jeff, where are you on the lighting plan?
We're still waiting for it. I think it's about a week out, and we're not asking for any waivers. It'll be modern. It will be up to, all modern specifications as far as construction, et cetera. It'll be box-type, fixtures we expect. I've seen some early with the work. Nothing jumped out as being a problem. What's interesting also is with the light spill for the fields. It's an interesting situation, but I don't think you're going to have any issues. It'll be interesting if somebody goes through and looks at, foot candles coming from the north onto this parcel. There'll be some interesting relationship to existing conditions.
Yeah, I mean, I understand that you're not looking for waivers on that, but it is part of the overall package that we're going to make sure that there are
Yeah,
appropriate safeguards.
it's about a week out, so
Yeah,
you'll see
okay.
that before the next
Yep.
hearing.
Okay, thank you.
The remainder of my comments relate to the stormwater management or drainage system. My comment number one was, I was looking for test pits at each of their infiltration systems that they're proposing. They have advised that they will coordinate test pits once the design is finalized. If the test pits aren't done before the close of the public hearing, I would just suggest that that would be a condition of approval if the board were to approve the project. My next, actually, comments 2 through 5 all relate to the drainage calculations, and rather than bore you with those, they've said that they will address each of those comments, and I will review the drainage calculations, the revised drainage calculations, when those are submitted. Comment number 6 under the stormwater management was in relation to, they're proposing a pump system for the stormwater. The driveway that goes down to the parking garage under building number 1, that parking garage, as proposed, is deep, so it's deeper than their infiltration system.
Right.
So the only way to drain that is to pump it back up to the infiltration systems. My recommendation is that they make sure that's connected to their emergency generator, so that during a power outage with heavy rains, that does not flood. They've said that they revised the plan so that it will be connected to the emergency generator, and they will submit details to the town prior to applying for a building permit. Number 7 was just a editorial issue with their operation and maintenance plan. They said they have addressed that. I just haven't seen that yet to confirm. And then the last comment, number 8, was in relation to some area drains and cleanouts. The area drains are small, basically catch basins in landscaped areas, and they had proposed hoods in those. And the hoods, if you're not familiar with what they are, they're a mechanism that you put on the outlet pipe to make sure that any floatables do not flow in. They stay in that structure rather than getting into the drainage system. The size of the structures that they were proposing would not allow for hoods to be installed. Their response was that they had removed the hoods from those structures. In discussion with Mr. Quinn today, I suggested for the area drains and the roof drains around the 2 buildings, there's 3 manholes total that the area drains discharge to before the infiltration systems. What I've asked them to do is show those manholes with a sump and a hood, so that any leaf matter or any floatables that get into the area drains are filtered out before they get into their infiltration systems, because that's the type of thing that will clog those infiltration systems and lead to failure. And they've agreed to do that. So that's where I am. That's my comments for now.
Any questions for Mr. Brennan?
Yeah. Are you satisfied with what you've seen so far with the operation and maintenance plan? And is it clear who has responsibility for that?
Yes.
In particular, forced payment, you got to be careful with that stuff. If there's a lot of sand that's applied during the winter time, that can get plugged up pretty quickly.
Yeah, and actually porous pavement, that was my thought on porous pavement for a long time, and UNH, the stormwater school up at UNH actually did a study on that, and they had 2 porous pavement parking lots, one that they maintained, took the sand off of it all the time, one that they didn't. And they found that over time, there really is not much of a difference in functionality between the 2. So while we still want them to maintain it, it's not as critical as everybody once thought.
Alan? Isn't good? No? Thank you. Susan, do you have anything?
With the intention to do the stormwater analysis before the design before the close of the hearing?
the stormwater analysis people have closed
The design of the infiltration systems.
The original calculations did show the stormwater design of the systems, but they were based on assumptions based on soil mapping and not actual field testing.
Right.
Soil mapping is a good first step, but you really want the field testing to verify that the soil texture is what you think it is, and the seasonal high groundwater is where it needs to be so that you actually get infiltration. So typically, it's better to have the test pits prior to having the final plans, but if they've done other testing on site, and I believe you have borings on site, correct? They've had borings on site that show sandy materials, so they may be comfortable enough to move forward with that. I always caution that that's great, but if it's a condition of approval, you get to right before construction, you do the test pits, and it shows a different either groundwater table or soil, you have to redesign it.
And that'll mean coming back here. So-
Correct.
Yeah, and I just have the concerns about conditions about post-approval review and approval.
Yep.
Because that's a condition, that's a concern with 40B
Right.
conditions. So if it can be done, it needs to be done. If there's some reason it can't be done or it's not, that kind of best practice to do it at this time of year, whatever it is, then I think we would ask Patrick to have a very detailed specification for the condition as to it must meet this specific, whatever the best stormwater, best management practice would be, that it would have to meet, then I think that's the condition, not just do it later and we'll look at it
Oh, no,
later.
no, no. We
Right, it
would
have to
establish
be-
performance standards.
Right, it would have to be a
Yeah.
very specific condition as to the performance standard.
Exactly.
Yes.
Okay.
And we will take a look at that, just what we wanted to do up until this evening, everything was looking great, we were feeling good about the design until we actually get through tonight, and I think we're getting some affirmation. That then allows us to go back, Carlton's going to make some of the changes, and we'll look at some of the further details. So for example, that trench drain, and we talked about the backup generator, et cetera, there might be some ways to tweak that a little bit to get some positive gravitational flow. So we're looking at that, so we're not in a position where we're going to finalize everything right now, but we'll be determining that after this evening.
But I think Susan's point is important. It would be this board's intention to have specific standards, and if you don't think they are achievable, the applicant really should get the test done now, otherwise they will be a permit condition. Right.
Yeah.
Okay, I would limit it solely to what Patrick Brennan just discussed. If there's any members of the public who have specific questions about his report, now would be an appropriate time. Yes, sir, if you could just come up to the mic since we're being televised and give your...
My name is Bill Hersey.
John, feel free to raise that
65 Hersey Street. Just like to comment on Mass Historical. You have the paper there, was talking.
Oh, right, but that's not something that he's addressed. I want to limit the questions now to what
Okay.
Mr. Brennan just talked about, and then we're going to get to historical.
You're gonna get to that?
Yes, we will.
Okay. The surface on the emergency exit, just say it's going to be pervious, is that what you said, or it's going to be asphalt? What is it going to be? It's going to be asphalt?
It's porous asphalt that looks just like regular asphalt. You can't tell the difference by looking at it.
How is it going to be when it's plowed?
It acts exactly like asphalt. If you, there's a place locally that has it, the BMW dealership in Rockland, right by the Route 3 interchange, exit 14.
Across from Home Depot, right?
Yes. That has porous asphalt in the car storage area to the right. That whole parking area is porous asphalt.
Okay. Another question I have is the snow removal on that emergency exit. Is the snow removal going to be all put on this property, or is it going to be put on Vehicle Park property? I want that discussed. I want that settled now, not later.
Yeah.
Where's the snow going to go?
They do show snow storage areas on their site. They don't show any off-site, but that's where they show their snow storage areas, is on site.
I mean, one of the questions you're going to is what's their capacity on site? And the second is, will it leach, if you will, off-site?
That's not my concern. But my concern is, it's the same as what Mr. Matthews has here of Bear Cove Park, the same
Yeah.
thing. I don't want to see any snow put on Bear Cove Park property, because therefore, I have to plow it, which is the truck that is the Bear Cove Park truck has to plow it. I don't want to see that.
Yep.
That's the point I'm trying to make.
Yep.
I want to make that.
Right.
That's all I have to say.
I think we
I
agree
want
with
that
that,
addressed.
John.
Yep.
Yeah, I think we agree with
Thank
that,
you.
John, so, yep.
Anyone else on this narrow issue here? Thank you.
Thank you.
We do have the Mass Historical letter dated November 18th.
Do we have another copy of that?
Do you have that, Jeff?
No, I'm wondering if I gave them all to you, maybe a surplus. Did you go grab that, Scott, from her?
Want to take mine?
Want to grab that from Susan real quick? Thanks, man. Sorry about that. Thank you. Yeah.
And Emily, has this been made available to members of the public?
You just got it.
Was available this evening.
We just got it, so.
Okay, so I would say that this is
Andrea's seen
most likely not an appropriate topic tonight because people have not had a chance to review the letter and to make sure that,
Right.
that they know what comments they want to make because they haven't seen it. So if you,
My comment is just, how is it done? How is it done? That's my question.
right, in part because, I guess, have you seen the letter as well?
Yeah.
Right, exactly. So I think what we should do is make sure it's available to you as well as to other members of the public so that at the next hearing, we can have a discussion about it. So that would be my
I can,
intention. Yeah.
I can answer that. The study was a full-fledged Phase 1 locational archaeological survey done with a permit from the Mass Historic Commission
Was there somebody,
by a licensed archaeologist.
was there somebody from the town with these people to?
That I do not know. I have to go back and review the report, but it was certainly done in accordance with all the standards.
Well, I have a vested interest because I have 3 family members that are missing.
Correct.
And there's no bodies
Right.
being found on both parcels, so I'm just wondering where the
Right.
bodies.
Yeah.
That's my concern. I'll address it next meeting then. Thank you.
Correct.
Emily, other than
I
this,
think we have that study that's on the website?
is it?
A summary? Summary? Right. 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 And it was done by a firm out of Pawtucket, Public Archaeology Laboratory, very well-renowned, very well-known,
I'll
and
address it
very
later.
respected.
I'll
So,
address it later. Thank
Yep,
you.
yep.
I want to know, was the applicant involved with this study? And
Yeah, yes.
Okay,
So the applicant was, it's PAL, what they did is I can go through, generally what, there is the summary, you folks have had that. There's an 88-page, more extensive detail, which is not for public consumption just because of location of different potential areas, et cetera. But the summary goes through, summarizes everything. That's submitted to Mass Historical Commission, and Ms. Simon, who's the State Historic Preservation Officer, goes through, she cites what was done, she cites the document, and then she winds up expressing an opinion with respect to where the proposed areas of disturbance are. And, basically, in their staff opinion, the residential development and boardwalk as proposed are unlikely to affect significant historic and archaeological resources. If the project changes, we're under an obligation to update any of the changes so that they can take a look at that and then cross-reference that with their findings and, make any further determinations if those are necessary. It also goes through the history, very interesting with respect to just the history of the site during the naval, the depot use, going through, having locational diggings, locating, fill and other materials that are consistent with that use, and then also with the use of removing all of the bunkers, et cetera. So that all plays into where they studied, what they looked at,
Yep.
and they go through all of their findings as well.
So I would encourage anyone who wants to get a copy of the document, will it be posted on the website?
It has been posted.
So it's all posted on the website, and if you need...
Right.
The summary
That's the
is-
summary document,
If
right.
you need some further follow-up, contact the zoning board administrative office.
I just want to reiterate what Mr. Taccio said about the archaeological information in particular being confidential. That's standard practice. You've got to be a licensed archaeologist to look at these things. They never release this information to the public, but we do have the summary of that information, so. I know we
Okay.
got Andrew Young from
Yep.
the Historic District.
Anyone,
Yeah.
yes?
I just,
I'm sorry, if you could just, hate to
Sorry.
impose on you, but if
Yeah.
you don't mind coming up and identifying
TV.
yourself for the record.
We're on TV tonight, Andrew.
Great.
My name is Beth Rockoff, 36 Pleasant Street. You said at the last meeting that you would discuss the burial site. Are you then saying now that you are not going to address it?
I anticipated having this report prior to this evening, and I don't think it's fair to the public to have a discussion before they've had a chance to look at it. So if, it looks like you've come prepared to address something specifically. I'm certainly open to having that discussion, knowing that we are also going to have a discussion at the next hearing as well. So it is your choice, since you're clearly prepared to make a presentation.
Well, my concern is that I was a member of the Historic Commission, and in 2013, there was a Warren article to address the issue of the almshouse and the gravesite at Beal Street. There is no record that we've been able to find as to where the gravesite actually is, but we have documentation certified by Eileen McCracken down in the clerk's office that states that there are close to 100 bodies that are buried there. And if the town, as well as those people that have had the property, have done as they are told and appropriately took care of making sure that that sensitive site was watched as construction was done for the Back River and for the Hingham Mutual. I know for a fact when Hingham Mutual first put their building there, there was a there was a body found, and this building was moved back from the river in order to preserve that area. There also is a crypt on that site, and there's documentation that when the Navy owned the property, as they were clearing the property before they were turning it back, they asked someone to go and check the crypt, and they found a body in that crypt. That body was not placed on that site, but if we have done appropriately, the land is getting smaller and smaller where the gravesite could be. And I feel like the town, in its history, and that's what we're documenting with a plaque for those bodies that were buried there, took care of the poor and the underprivileged, that we owe them now that same respect for their bodies. And I know, Pal, I've read their report, and the Historic Commission says that, they don't think it will be, but they did specifically state in their letter that out of the 12 acres, there is approximately 3.2 acres that are moderately sensitive and 6.4 that have low sensitivity. I don't know specifically what low sensitivity is versus what high or moderate sensitivity is. It's way above my pay grade. But if that's the place where some of those bodies are, I think we at least owe some kind of respect to have, when they're doing this construction, somebody who's trained as an archaeologist on site to make sure that if they do come upon a grave, that it's appropriately taken care of. I don't know what the procedure is. I don't know archaeologically how that's done. But I feel that, number one, that's the thing. And the other thing is, when I was researching all of this business about burial grounds, and this is way, way above my pay grade because I'm just a nurse, I'm certainly not a lawyer, there's general court laws, chapter 114, section 43, that states burial grounds especially in section 17, it says, that are over 100 years old, which this are, it has to go to the court in order to be able to build on those sites. So that's way above my pay grade, that's more in your category, but I think somebody should address those issues, because we may have done something wrong because we didn't know the bodies were still there, but now that we do, I think we owe it.
Okay.
Do you know if there's any history of this site being used as a, not used, but winding up being a graveyard for Native Americans?
Yes, it is. And there is documentation, and they have specifications in that archaeological privileged information that there is space that has found, I forget the specific native. But there is documentation on that site that there is. I believe that's closer to the river, but I don't know that for a fact, and I'm not privileged to that information.
Okay. Thank you.
Can I comment on that?
One second. Is there anything that you wanted to submit in writing to the board, or do you want to, I mean,
Well,
your
I-
comments were extremely helpful, but if there's something in addition, you
Well,
can...
I mean, I have here just your letters, I have records that Jim Clark and Eileen McCracken went
Yeah.
through and found death certificates, some of which, you know, as...
Can I get you to go back to the mic?
Go back.
I can make copies for you if you would like, if those are relevant to have the death certificates. I do, in the Historic Commission office, there is a record of at least 68 of them, which I alphabetized. Eileen has made copies of many of the death certificates. I can give you those. I did give you a copy of John Richardson's map, which shows where they specifically found remains. So I know it's a sensitive site, and I know on the Warren article, there was a detailed list, the history of the land that was purchased by the Navy. At the time when the Navy was there, they also allowed the almshouse people to stay within that almshouse. And I can't believe that the Navy would desecrate graves in a graveyard, and they, at that time, knew where this gravesite was. So then they gave the land back, and Project Turnabout got a section of it, and that stayed until 2004. But as to where these graves are, I'm sorry, I just don't know, and we can't find it through any of the history.
You mentioned a map. I'm
Yeah,
not sure.
we don't think
I
we
haven't-
have the map. Could,
I presented you with a map at the last meeting, after the meeting, but I can
Oh, after the
certainly,
Okay,
I can
so we'll-
certainly get you another
Okay.
copy of that.
Okay, thank you.
Yeah, if I
One second. Jeff,
So, Mrs. Rockoff was good enough to give me the map as well, so I followed up on a lot of these issues, and that's been provided. That was part of the Mass Historic Commission's records. So all of the records from Hingham was basically provided to PAL. You know, there are appendices to the report that go through these. Also, with respect to the Native American, there was a representative of the Mashpee Wampanoag tribe that participated. As far as the other question about not knowing low to moderate sensitivity, that's outlined. So I did look at all of that, and what it does is it looks at, say, for example, the main core where the insurance building is, where we know that the bunkers were at, and where we can actually look at, you know, whether it was stump burial, et cetera. So they've identified that by going through, making various historical research that that's low sensitivity. What they then did was go to the other moderate areas, and they actually went out and would dig and sift through and have inventories of what they located. So what they were locating and doing those locational archaeological reconnaissance, just you know, broken up china and other you know, other things that are kind of trash from, you know, earlier time periods. What's interesting also is when you go through the Project Turnabout area, which was basically a drug rehabilitation center, that wasn't located on this site, but that was where the Back River development is, almshouse, et cetera. This was all, you know, there was no property line really making any distinctions at that time. So they didn't go on to that land, but they were able to also document some of the uses over there before, all of the land went into different titles after the United States government. So it handles all of that. And I can't say that I saw individual death certificates, but it did talk about having various burial practices in different areas. And then also the crypt that they talk about, it's located, they talk about if there was somebody who had passed away, for example, in the winter when the ground was frozen, they speculated that that was used to house the bodies until the weather turned, so that they could actually intern the bodies wherever that may be. What happened as well is during the naval period, someone did find some remains in there. They were taken out, et cetera, and the Navy actually has used that for some period of years as an office. So people look at it and they think, it's got some special, significance, but what actually happened, if you go through the history, people walked in there from wherever and they cleaned it up, they brought in their tables and chairs, and that's where they were every day. So that's just one example of the day-to-day use, disturbance, and just the changing of the site from whatever may have been there to its, post-naval use and what they actually found when they went out there just recently.
Yeah, thank you. Mr. Hersey?
I kind of dispute that about a crypt being an office, but I'll let that go for tonight. We'll go back to that. The building that's there right now, the insurance building, in the original plan was not supposed to be there. It was moved back towards Bear Cove, Back River condos, because of the fact that there was a good suspicion, or they found bodies there, so they had to move the building. I want to make sure that's clear, that that's why it's where it is today. Thank you.
Thank you. Yes, ma'am.
Andrea Young, 18 Back River Road. I happen to provide Pal with the information about the crypt, and the article that it references basically said that the Navy asked a couple of guys to go in there and clean up the crypt because they wanted to use it as an office. Of course, when they went in there and found the bodies, I think they changed their mind. And if you look at, there's no evidence that that's the case. So, and if you also look at the crypts, I don't think anybody would want to stay in there for any length of time.
Anyone else? Then we will continue this discussion at our next hearing. The next item I was going to cover, Emily, unless you suggest otherwise, is letting the applicant review the supplement to the fiscal impact analysis that they've given us.
Do you have the copy of that?
Is there someone who can address that?
Let me pull it out. We didn't know that we were going to address that this evening, so we didn't bring it with us.
We can put that, I'm sorry?
Do you have it?
Yeah. No, we can, if you didn't bring the right person, we'll certainly continue that issue.
Thank you.
Because it is something that is important for us to look at. Did you have any other topics that you wanted to cover this evening?
I think that's it for this evening. We've covered everything that we needed, and that, Mr. Brennan had was really helpful to us, so we appreciate that.
Emily, any other items for this evening on this project? Susan?
No.
Okay, so we have received other public comments, and if there's any members of the public who would like to talk about the project beyond what we have discussed this evening, now is the time. And again, we were going to have many opportunities, including tonight, to open this up to public discussion. So, yes, sir.
Thank you, Mr. Chairman. Good evening, Mr. Chairman, members of the board. My name is John Witten. I'm an attorney with the law firm of Huggins and Witten. We're in Duxbury and Newton, Massachusetts. And Mr. Chairman, members of the board, I represent a lot of cities and towns in the Commonwealth, and I do a lot of 40B litigation. I've written a lot on 40B. I know the statute quite well, and I only say that by way of background so I can address the main reason why I'm here. And that is to urge the Board of Appeals to deny this project pursuant to the town's status as consistent with local needs. It's fair to the applicant before the applicant spends more money on this project. It's fair to the town because you, this town, unlike most towns in the Commonwealth, have achieved the magic standard of consistent with local needs. You've achieved it for this particular project by the applicant's own actions. Withdrawing their appeal to DHCD means that your standard through council, your standard or your announcement that you're consistent with local needs is now applicable to this project. So with that status, with that lofty status, the question is, what can the board do with it? Based on the litany of issues that Mass Housing heard from your Board of Selectmen, and I'll just read them briefly, although I know the board is aware with it. Municipalities concerned that the concept plan is inconsistent with the surrounding residential neighborhood, and I represent the Back River Condominium Trust, and many of the residents are here tonight. The municipality believes that the density is incompatible. The municipality is concerned that a single access would provide circulation issues. The municipality is concerned about potential additional traffic. The municipality believes that a substantial reconfiguration of 3A and Beal Street is required. The municipality is concerned about the impact on Lynch Fields. And it goes on and on and on. With those level of concerns, if this were a special permit or a variance, we think the board would have no question but to deny the project. It doesn't meet any of the Hingham zoning bylaw criteria. But now, because you're consistent with local needs, the Hingham zoning bylaw applies. This isn't your standard 40B, and I know this board is extremely experienced with 40Bs. This premise that 40B is a waiver of all local regulations might apply in the normative case in most municipalities. It doesn't apply here. So that would mean, respectfully to the board, that this project has to earn your support. It has to be the right project, the one in a million development where zoning ignorance, removing the requirements of normative zoning makes sense. And respectfully to the board, on behalf of my clients, that's not the case here. It's the wrong project in the wrong location and the wrong density. It's particularly egregious that the applicant would take such advantage of this renowned park that it abuts. It overshadows it, it outmasses it, it's completely incompatible, and that's part of the town's comment letter to Mass Housing. If the town wasn't consistent with local needs, I would be here making a very different argument. I would be making an uneconomic argument. I'd be making a consistent with local needs argument. But again, respectfully, I don't have to do that. The zoning bylaw applies, and it only doesn't apply if this board chooses to waive regulations that it has no rational basis for waiving. So again, I would respectfully ask the board to simply deny, and deny it as quickly as possible so the applicant doesn't spend any more money, any more resources. The applicant has no appeal to the Housing Appeals Committee. It's over. It's over, and Hingham has earned this status. And if this project doesn't deserve a denial, then we don't know what project would, given its massing, given its scale, given its location on this particular parcel. Thank you, Mr. Chairman.
Let me ask, what's your view if we were to deny or if they were to withdraw, whether or not their position could shift in the next application for the same project? Whether or not there would be any res judicata effect of this proceeding, or whether or not we would be in a tougher spot with a new application.
Excellent question, Mr. Chairman. And it would be res judicata if the board negotiated a withdrawal based on that the applicant would agree not to refile. I mean, this board knows 40B, you're not going to be protected forever. So my clients are fully aware that this inoculation status that the town has doesn't last forever. It's too hard to maintain it over the long period of time.
I'm not talking forever, I'm talking about the 6 months from now when there's a new application by this applicant.
Could this applicant withdraw and refile in 6 months?
Yes.
Well, my opinion is you'd still be consistent with local needs based on all of the work of council. I mean, Hingham is consistent with local needs. DHCD may take one position, the Housing Appeals Committee may take another, but I think town council and the board, and I know you're consistent with local needs. You're consistent with local needs based on the representation of this applicant. So if it were to withdraw, it's, in my opinion, bound by that prior statement, another letter to DHCD withdrawing their application. Their memorandum of agreement with the Board of Selectmen makes it clear that they believe they're consistent, you're consistent with local needs. So whether it would have a preclusive effect, that would be something you could negotiate. But my position on behalf of my clients is they've already made that decision. They've already put in writing to DHCD and to your Board of Selectmen that this project is not consistent with local needs pursuant to the statute.
Okay. Anyone else? Any questions for this attorney while we have him in front of us?
I'd be interested in the applicant. They may not be prepared tonight because they just got the letter, but the applicant, either local counsel or I believe they have Boston counsel, respond on this question of what the effect of their letter is. I don't, Mr. Witten's arguing that their withdrawal in this case would apply in the future. I'd be interested in whether or not they share that opinion. So I'd like to really hear their sides of it, and then weigh in based on my review of the regulations and the wordings of the letter that were written. So I don't think I'm prepared to weigh in on that tonight.
I don't think this is the right time to have a detailed legal discussion, but it was important to get your input in that discussion.
And I appreciate that, Mr. Chairman. If I could just take one more minute and add, the withdrawal of the appeal to DHCD is dispositive. So
it's dispositive for this proceeding.
Correct.
For this application, right?
Right,
Correct.
but that's why I asked about the next application.
So, in 40B world, you take one step at a time, and the town is either one step ahead or one step behind. Hingham is one step ahead. So we're willing, on behalf of my clients, we're willing to gamble that Hingham will continue to be consistent with local needs. So even a denial or a withdrawal of this project, if were reapplied, you would still be consistent with local needs, and I could still stand up here 6 months or 5 years from now and make that same argument. We're comfortable with that risk, and my clients understand that risk, and obviously the board understands that risk. But with 40B, you have to take it as they come. I don't think, and again, I'm not speaking to you particularly, but every town will lose its consistent with local needs status over time. There are very few that can maintain it. Cambridge and Amherst are two exceptions because they have so many units or their land area is so dramatic. But when you have the status, you have to use it, respectfully, because when you have a project that you can't tolerate, that's why you've worked so hard to get the status. So again, we're willing to take that gamble that that status might get lost in the future and this applicant might come back. We have no choice, rather than to deal with a project that's totally incompatible when you have the power to make it go away.
Thank you.
Thank you, Mr. Chairman.
Anyone else? Yes, ma'am.
Laura Burns, 96 Hersey Street. Thank you for the opportunity to address the board. I wanted to speak to you about just this issue that we were just discussing, because I understand that the board might be concerned that the Board of Selectmen had made a development agreement with a developer before you have finished your proceedings. And maybe it's because of what I've done in the past, but it
You have experience as a
it feels
selectman,
differently
yes.
to me. The job of the Board of Selectmen is very different from your job. Your job is to look at every applicant that comes before you and examine that particular project relative to the laws and regulations, decide whether it fits or not. The Board of Selectmen's job is to think about the whole town as far ahead in the future as can possibly be done, which is not necessarily all that far. And I think that that is what the board did when it worked on this development agreement, was thinking about, in the interest of the entire town, what is the future of the entire town with regard to 40B. And so I feel that whatever agreement the board made with the developer, it is of course contingent on your decision, obviously. I'm not sure, didn't read the agreement, but I'm pretty sure it's written in that agreement that it's contingent on your decision, because it is. So we all know that your decision comes first before anything else happens. So I'm not too concerned about them having stepped on your toes or you having stepped on their toes, because your jobs are different. And so as it comes to this question of whether or not it makes sense to rely on the Hingham being able to continue in our protected status, in our safe harbor status after May 15th, if we turn down this project based on the idea that we are in the safe harbor status, I'll say something to you that I could not say if I were still sitting on the Board of Selectmen. And when I did sit on the Board of Selectmen, I was of the opinion that Hingham had met its 10% for all the reasons that we've spoken of so many times, and that we should stick to that point of view. And I know a couple of times the ZBA asked us, do you still think that? We said, yes, we still think that. And I still actually do think that I mean, I haven't changed my mind about that. However, if I were sitting on the Board of Selectmen today, I could not say to you what I can say to you now, which is that I believe that if we allow the safe harbor to pass away without having taken steps towards meeting DHCD's idea of our 20%, that we not only do know that we will have to spend money litigating not just this property, but every other 40B that will drop on us at that time. But I don't believe that we will prevail. And that is my biggest concern here, that I don't believe that we will find that the Supreme Judicial Court agrees with us. That I think that they will think that they agree with the Housing Appeals Court, that the Erickson project is not really a rental project, although obviously it is, because there's only one landowner who pays the property tax bill, and that's how you know who owns something, but never mind. I think that from the point of view of the 40B statute and its intent, they will conclude along with the HCD that is some kind of a hybrid, and maybe they'll give us 30% instead of 25%, but I do not think that we will be victorious in the courts, and we will have spent a tremendous amount of money getting to that point. And so that's one result, spend a tremendous amount of money and lose, and the other result is, of course, all the other 40B projects that are waiting out there in the wings, which after the safe harbor expires, we will not have any leverage to negotiate any development agreements with anyone. And that is the advantage that we have when we are dealing with this project. If this project goes away, perhaps these applicants will come back, as you asked, Mr. Fisher, and they will, perhaps they will change their mind about whether or not we are, consistent with local needs, or property will still be on the market. Somebody else will come along. They will file another 330, unit thing. And if you're concerned about Beal Street, and I am concerned about Beal Street, I think the scariest future for Beal Street would be to turn down this project and leave Beal Street open to redevelopment on the Talbot's parcel. I spoke to somebody who had occasion to be in Talbot's, the building, recently. They think it's maybe 50% occupied. I do not think it's going to be another corporate headquarters. I don't think that's its future. And as we know, housing, office building stuff is not really going very well in Hingham right now, North Hingham, South Hingham, anywhere. Its most plausible redevelopment is as a residential 40B project if we are not consistent with local needs. So it makes perfect sense that Mr. Witten's clients would be willing to take the risk that we would continue to be consistent with 40B on behalf of the entire town, and all the 40B projects exactly like this or worse that we will have no leverage over, but will come down everywhere in town, on behalf of Beal Street, which also still has more developable parcels that we will have no control over what that looks like. We'll have no leverage to do a development agreement on behalf of Beal Street, on behalf of the whole town, on behalf of the taxpayers who have to pay for all that litigation. Much as I agree with all the criticisms of this project for being out of proportion and not belonging and overlooking the park, and I don't like that, I think of all the really rational and reasonable things that we can expect to happen, this might be the least worst. And so I would encourage the board to approve this project because it's not a good risk for the town, however good a risk it may be for the immediate neighbors. It's not a good risk for the town to take. Thank you very much.
Thank you.
Thank you.
Excuse me, Joe, can I
Sure, Susan.
I just add something? The first thing that I just want to say, and I know the board has said it in the past, is, and I think Ms. Burns just did indicate at the beginning, that what the Board of Selectmen didn't do was really irrelevant to all this. The fact of the matter is, the zoning board in this time and place in Hingham with 40B is in an atypical situation for this Board of Appeals or any Board of Appeals, where typically a project comes in, you look at it on its merits in its own little space in the town, and you render a decision. But as this board knows, and it's been going on for 15 years now, the way the law and the regulations are set up is the decision, and to a certain degree, it is a policy decision, gets made at this board's level as mandated by the regulations, that this board says, do we assert a safe harbor or not? Do we send that letter or not? Do we, notwithstanding that we take the position we're at 10%, allow projects to proceed, which the board has done in the past? Do we deny a project, whether we believe we're at 10% or not, which the board did do on Ward Street? So the board is in a position to look at what the impacts are, what the safe harbors are or aren't, what the likelihood of success on those are. And I do think, it does put the board in a atypical situation for, as compared to other projects, of having to make decisions that look at successive merits of any type of appeal, whether it's on here, if it's future projects getting in the pipeline, and whether or not the 10% argument prevails in the future or not, and those types of issues. So, as you said, you're not kind of talking through all of those necessarily tonight, but it is the context that a legal context in which I think the board is placed at this point in time in Hingham history with 40Bs. So I just, thought I might kind of summarize that.
Thank you. I mean, I think, just to make it clear to the community, that this board's view is that the town has reached the 10% threshold. We have asserted it with the DHCD. We've asserted it with the courts. We recognize that DHCD and the Housing Appeals Committee have taken a different view, and ultimately their view may prevail. Depends on how courts rule. So far, a court has not ruled on the issue. And we are doing our best to protect the interests of the town. We are looking at projects, and in those circumstances where we have asserted that the 10% threshold has been met, we have evaluated each project to make sure that it is consistent with the town's goals, and it would be our intention to proceed with this project in the same way. But there should be no suggestion that the board has wavered in its view that we've achieved the 10%, and we do recognize the litigation risks associated with that. Mr. Isidore.
Bruce, before you speak, I just want to say one thing in response to Ms. Burns. I am cognizant of, as Susan said, this is a big moment for this town. At the risk of being too melodramatic, it is a big moment. And we are sort of setting policy in how we decide to proceed with this. And I do agree that the selectman's role is to look to the benefit of the town as a whole. But I take a look at this project, I take a look at Avalon 2, and although it's not a 40B, the third or second residential building on the west side of the shipyard, if we approve this at 220, total that up, that's almost 500 residential units. That's 487. That's about a 5.5% increase in the total number of housing units in the entire town. And that's my concern. And however we can address this, I think that's I'm not going to say fundamental change, but it's a significant change in the character of this part of town. And I think, in argument, there's a real equity issue here, too. I mean, I'm sure people in South Hingham and Hingham Square and Hingham Center, great, it's up by the shipyard, what's the problem? Well, we're not an industrial area, and yes, there is some infrastructure there. I question how adequate that infrastructure is, in particular 3A. So those are the things I'm wrestling with here, and I just want to sort of get that off my chest for tonight, so, okay. Sorry.
Bruce Isidore, who is back from his honeymoon. Congratulations.
Ready for bear. Actually, I wasn't going to speak tonight, but I actually heard, first of all, I thought John Witten's position on behalf of the condominium association was very succinct and to the point and very appropriate. And I wasn't going to say anything further because I think silence has its position, except after hearing Ms. Burns's talk and then even followed up by Susan Murphy's indication, and even Mr. Freeman's, what I thought was an appropriate statement in our view on the condominium association and my personal view as a resident. But I don't think this is a policy decision. I took a look at the zoning bylaws before coming in here and some other laws to try and determine what the authority is of the Board of Appeals. And it says that the Board of Appeals that the selectmen will hire people with the educational experience background to be able to make decisions for the matters that are before them. And what's before you is not policy decisions about how to protect the town or what's the best way for you to do things that would be dealing with the future that you don't even know. What I think you need to do is not to be in the situation that Ms. Burns is presenting, because that puts you in an untenable position. You're not here to save the town. What you're here to do is to either decide a variance request, decide a special permit request, decide an appeal from a building permit, the matter before it, or in this case, to look at a comprehensive permit. This is a case of a comprehensive permit request where we have two safeguards that have been met, safe harbors. One is the 1-year safe harbor, and one is the position that this board has always taken, that the town has always taken, and we've met the 10%. Hey, Mr. Witten has said it very succinctly. Okay, this project is completely contrary to zoning. If we were looking at waivers, not just waivers with respect to setbacks and height, but we're looking at the waivers to use, waivers to what zoning district it's in, there really can't be a project that will come before you in which you had a safe harbor, in which other than maybe if you had a safe harbor for Linden Ponds, this is the most inappropriate project with respect to current zoning that you might have. And I would just ask this board not to be doing what the selectmen did, not to be doing issues about how you save the town. You have a position, you maintain the 10%, as Mr. Fisher has indicated, that's your position. This project should be denied. It doesn't comply with zoning. There's no appeal from this project. We can deal with issues of whether they've waived their appeal in their future, whether it's res judicata effect. That's a position that possibly could be taken later. It's possible that they could come in with another project, and that project, somehow we lose on our position. We should take our chances with that. And at some point, projects will be presented, and at some point we'll reach a safe harbor that the court will agree with if the court doesn't agree with us now. And at that point, as Mr. Witten has indicated, we will rely on the safe harbor until such time as we don't have it. We should not be doing policy decisions within the ZBA. We have a project before, it's 220 units on a spot that's zoned office park. As Attorney Witten has indicated, if this project came in under a special permit or anything else, or a variance request, how about a variance request to see, we have an office zone on the parcel, and we'd like to have a variance to see if we could build 220 units that exceeds the height limitations, doesn't comply with parking, doesn't comply with setbacks, where would that go? And I think Attorney Witten is correct. Let's not go down traffic studies and drainage studies and all of these other things if, in fact, we have the safe harbor that says, look, this project's not appropriate. We're not going to be influenced by the development agreement and the fact that $1 million has been negotiated and presented to the board, which is elephant in the closet, but we know that that was part of the development agreement with the selectmen. We shouldn't be influenced by that. And we go forward. It's denied. they want to refile at some point, they refile. Thank you.
Anyone else? Okay. We certainly have a lot to think about. We also have our goal, which is to make sure that we're adhering to the 40B requirements. And then ultimately, we will be deciding the questions that have been asked this evening, whether or not we can appropriately permit this under 40B or whether or not it should be denied. What is our schedule? Emily?
So we don't have a continued hearing date set just yet. It sounds like we may receive a lighting plan within a week or so. I don't know when the rest of the plans may be reviewed or final responses to traffic, but I can envision potentially a meeting in early January where we may be able to wrap up some of the engineering peer reviews, maybe both traffic and civil, if the applicant is able to provide complete plans in advance. We have a regular meeting scheduled for January 11th. That is an option. After that, we may lose one member of the panel for a little bit of time. Looking at dates.
So I'd like to set a date consistent with what we can expect from the applicant and our schedule. So you said we currently have a meeting set for
We have December 21st and January 11th.
January 11th, right.
Regular meetings.
January 11th. Are you available for that?
We could, I just discussed it with Mr. Quinn. I mean, we could actually do that January 4th, which means that he would submit his plans by December 21st. He said he's able to meet that date. So if you folks wanted to do the 4th, because I know that the end of January gets into some scheduling problems, that would be available for us.
Are you available then?
January 4th, yes.
Are you unavailable on the 11th? I mean, we don't have much scheduled for that evening.
No, I'm good for the first 2 weeks in January.
So
After
the
that,
4th?
I couldn't commit till mid-February.
Okay, so the
After
4th
that.
and 11th. What about you?
The 11th is better for me.
Yeah, and the 11th is better.
I am available the 11th,
Okay.
yes.
So I would.
We don't have to do two in a row.
Right. So I would recommend that we continue this to the 11th. And that means that I'd like to get the reports, to the extent that they're going to be submitted, available at least a week before. It's tough when we receive things that same day and then the public doesn't know, we don't know. And then on that time, I also do want to make sure that we do cover mass historical issues. And so to the extent that anyone needs to get information from the zoning board, please come in ahead of time so that we can have that discussion on the 11th as well.
Great.
Again, that summary is posted on the zoning board's 40B, pending 40B applications webpage. So,
It has been.
yeah, it has been
some
for a while.
time.
Yeah, yeah.
Emily and I have a list
of
all the open matters or discussion items.
Yes.
Sure.
So you mentioned the historical, there was the fiscal impact, the revised waiver list,
Yep.
the traffic follow-up, in particular, the recommendations from Jeff Dirk and whether or not they're going to accept them. Sewer hasn't been discussed, I
Still
don't
waiting
believe,
for
in
that.
any detail. Then the civil follow-up on the stormwater, and I don't know if there's anything else that Patrick would put in that category, and the lighting plan. Am I missing anything, Emily? Those are the items that we,
Which of those do you think you'd be able to get to us by the end of the year, or beginning of January?
I believe that we would be able to get all of those to you with the only contingency being sewer.
Yep.
There's a Weston and Sampson initial draft that's been done there. Sewer Commission is looking at additional work that's not within our control, but to the extent that we can speak with your agent and see if we can work on that, it would be great to have that, but based on the progress to date and then the holiday, I would think that that wouldn't be ready.
Okay. So then, I'll just pull this up. Okay, so I'd accept the motion to continue this hearing to January 11th at 7 PM.
So moved.
Second?
So
All
we'll
in
talk
favor?
about
Aye.
setting this.
We are going to continue this hearing then to the 11th. If people wanted to leave, please be quiet. We actually have some other business that we need to handle.
Thank you very much.
So we'll pause for a minute or two, so to accommodate folks who are leaving.
But you're gonna have to get caught up on that, because what's gonna happen from here is, you're gonna basically be
Good to see you.
near final position.
Not so bad, I never get it right.
We have a visitor
Okay.
from the advisory committee here this evening.
So, is HCAM ready?
You're on.
Okay, we are resuming the hearing. The next item on our agenda is to have a discussion of proposed zoning article amendments. Emily, can you walk us through what we have?
Sure. So, we have some drafts in front of you that have been labeled by number and may not exactly match the agenda. So, but I'm just going to go through them as they were presented in your packet. Article 1, we discussed briefly at your last meeting. And the intent of this is to provide definitions or purposes of each of the current zoning districts. It's not intended to change or create any new regulations, but rather to refine or clarify in the bylaw what each district is intended to do.
Right, so you've included purpose language here, which
Yeah.
which we need.
Which we need. It's similar to each and every overlay district. It starts with a purpose. But our regular based zoning doesn't include any purposes. So it's got sort of an introduction to the class of use. So we've got residential districts, business districts, official and open space and recreation districts, industrial and office districts. And then within each of those, a brief sentence or two about what the purpose is, where they are generally located. I mean, these, in some, it was a little bit tricky. When we adopt an overlay district, the regulation, it starts with a purpose and it's clear from the get-go
Right.
what is intended. Some of these are districts we've had since 1941, and the record's not abundantly clear what the purpose was. So we had to infer in developing this draft from the table of uses and from the dimensional requirements what the purpose is generally. And these may need some refinement through the hearing process.
Did we look at the historical records to see if there was
So,
items that discuss the
Can I
purpose?
ask why you feel that these descriptions are necessary?
I don't know that they're necessary. I think it's a good standard practice when we adopt zoning districts to be clear about what the intended purpose of that district is. So we've looked at other communities, specifically Amherst. I will say that this practice is much more common out of state than it is in Massachusetts. And it seems, I don't understand the discrepancy between overlay districts, which have very clear defined purposes, and regular-based zoning. But what the zoning board does when they review both special permits and variances, right, there are findings that you make about whether what is being proposed is consistent with the intent and purpose of the bylaw. And I hear you say very often, oh, it's a residential use in a residential district. We are inferring something that when you make that statement that isn't expressly in the bylaw. And so it seems to make sense that there's a statement that helps guide you when you're trying to make those findings.
Well, but to follow up on that, I think it's very easy, and it would not be a mistake for this board to say, it's residential use in a residential area, so that's fine, but...
It's a logical inference.
Right, but going, I'm just looking at what you have for Residence C, the purpose of Residence District C is to provide for lower density residential areas. So then, when we made the next finding, we would say, well, is this actually consistent with a lower density residential use? So it would restrict to some extent what our purview would be.
Right. The thing the only question I have, and I just am hanging around here, sorry.
this is
So I
great.
hadn't seen these.
We like you
in
hanging around
advance,
here.
Is, now even though it was before my time on the planning board, my understanding on Residence B and C was it was related to Board of Health septic system related issues. It wasn't lower density necessarily for the sake of lower density. It's mostly areas that are, that's all, basically B and C, I believe, are all areas that are not within the town sewer district. And,
Not anymore.
well, not anymore, well, that, right, and some of those may need to be changed. So for example, that area down on Hull Street is B, which is 30,000, C. But now it's sewered, so it could appropriately be A, given the density down there. So I would just, I almost think, to say we just want lower density residence C isn't the reason why C was, it was created for lower density, but it was because of impacts on
Septic versus sewer.
septic and those types of things. So I just think that it's important to,
Protection, but I don't know that zoning really deals with Board of Health regulations, so they're separate and distinct. So while that might have been part of the conversation when it was originally adopted.
But that was the public health, safety, and welfare reason for the larger districts, because of the impacts. I think that's a valid planning goal. It was a health issue. So I just think that, I don't think this is a bad idea. I think it's unusual, as you said, in Massachusetts. I don't think I've seen any zoning bylaws, although I haven't looked at Amherst, that create for regular districts as opposed to overlay districts, this type. But particularly where there was a rationale behind the residence districts, particularly B and C, I think that it's worth going back and looking at what the intent was. And maybe that raises a question of, is that even still applicable anymore from a planning perspective? But I just think maybe a little more digging, and I'm not looking to make more work, I just feel like going to the original legislative intent is important.
I agree, but wasn't able to do it for every district before tonight, and
Right.
assume that that can happen through the public hearing process. And that, so it wouldn't be inconsistent to add after Residence C, to provide for lower density residential areas for public health and environmental protection.
Right.
Right?
Right.
So what I was able to do was go back to, so I made inferences from most of the residential districts. With the, D and E, we have clearer records, though they have changed over time to some extent, so that was muddled together a little bit. Some of the industrial districts, I will, not to complicate things overly, I think part of this originated with the official and open space district. And so we did go back to 1977 and reviewed the original warrant articles, the recommendations made at town meeting on that district. There was very limited discussion, and it said basically that the intent was to create open space areas and to allow uses that were already in effect, to encourage uses that were already there, so to match what was on the ground. So we started with that, and it's because it's something that the board has been discussing to some extent in relation to, previously filed applications. It's an open space district. What does open space mean? And so this helps the board better understand what I hope that the intent is to better understand what the purpose of the official and open space and other recreational districts may be, but it is not something that is already a part of the record in a clear way. So we would have to review these carefully through a hearing process, if it gets to a hearing process, if it ultimately is submitted. So the deadline to submit these articles is tomorrow. It's a bit to absorb. In reviewing some of the other zoning districts to try to figure out what the purpose was when they were originally proposed, we did discover that in 1985, the limited industrial park district was proposed. It was, the town meeting transcripts suggest that, well, they confirm that that zoning was actually not adopted. And the town clerk submitted it to the Attorney General anyway. So it was reflected on our zoning maps as of 1985, but it seems that town meeting maybe had not adopted it. So, yeah.
This was very interesting news.
So this is a worthwhile exercise.
What I've asked Emily to do, I mean, there's two issues here. I mean, town meeting never adopted a limited industrial district, but there are property owners and businesses that have operated and have been granted permits as if it exists. And so there's a real issue there. You know, one option, I've asked Emily, that I just found this out tonight before this hearing, before your meeting started. I've asked Emily to provide me with the original warrant article, the transcripts, and then what actually was sent up to the Attorney General's office back in 1985. That seems to be a period where there was a little bit of confusion with some articles in the AG's office. And then, you know, and I'm going to call the municipal law unit tomorrow and talk to the person in charge up there. But one of the options, I don't know if there's some sort of latches. I mean, estoppel usually doesn't apply against municipalities. Right. But, you know, this has been going on for 30 years. So there's always exceptions to every rule. So, but it may be worthwhile even to just submit it, because it can be pulled back, to submit the original 1985 article as it's been reflected, or I don't know, because it's been modified over the years. Like the use table's been modified. I mean, I don't know you know, the selectmen hate placeholders, but this is one case where I would, you know, kind of do a mea culpa and say I recommended a placeholder, that there be potentially an article to adopt and affirm the limited industrial district in order to protect the rights of those property owners that have been operating under it, on the outside chance that it turns out that they are now non-conforming uses, which I just think would really just be so inequitable. I can't imagine. But it's up to the board. I mean, that was a really stunning.
Yeah, it's just found today.
Fact.
Say it one more time so I.
So in 1985, the planning board, I believe, proposed the creation of a limited industrial district,
right,
and then proposed a certain area of town where that would be located, the North School property. And
yeah, it's basically the areas behind the Stop and Shop.
Okay.
Yep.
So between Lincoln 3A and
It's like
Beal Street.
is the bank
So is the
Bank of
project that
America?
we're looking at now affected by this?
No, that was
Okay.
office.
Okay.
It's all the A.W. Perry buildings and.
Yeah,
Okay.
but
adult
in that
daycare
general
center,
area.
Yeah.
Okay.
The
So-
Alzheimer daycare.
There was interesting, the town meeting transcripts show that there was a lot of discussion. The advisory committee actually recommended no action, but the planning board, by split vote, but majority vote, did support it. And so they advocated for it on the floor of town meeting. There was concern in the neighborhood, this will sound familiar, that the north part of town was overburdened with development, and so and so ultimately there was a vote to adopt the Article 24 and Article 25. And it didn't pass by 2/3.
It did not.
It did not. And so there was another vote to take up the advisory committee's recommendation of no action. That passed unanimously. There was a motion to reconsider, and that failed.
Okay.
So it was not created. Nonetheless, the town clerk submitted to the Attorney General records as if it had been adopted, and indicated in their records, I think, from what I looked at today, that it was approved by some number that doesn't match any of those votes. So.
What was the use prior to the,
I think it was official in open space, the North School. So,
So, and then the Attorney General approved it.
Well, based on the
On what was submitted.
certification
Right,
from,
I understand.
yeah.
And then it's now reflected in,
and as of 1985, it was shown on our zoning map.
Correct.
So nobody caught it right away, and 3 years later, in 1988, the planning board amended things that were shown on it.
Table of use regulations, everything.
And then in 2002, there was another minor modification of it.
And then I think over time, the use table has been updated and revised.
but the subsequent revisions have
Did not
been,
create the district.
Right.
I understand, but
Yeah.
they sort of incorporated it and
Yeah.
built on it, and those were submitted to the state and
Yeah.
approved. So it seems to me that to the extent they were incorporated by reference in the next submission
It
and
was.
approved,
Yeah, it wasn't referencing the location of the district, though. It was
But
like saying.
but as long as it used the
But
map.
town meeting kind of later almost affirmed it by modifying it. I
Right,
mean,
that's exactly right.
There's got to be some sort of,
So, I mean, it sounds very unclean, but it also sounds like it's been handled. But I support you in getting this fully handled.
Yeah, and I mean, maybe, I mean, we're looking at this today, so hopefully there's something
Okay.
out there that cleans it up already, but maybe the placeholder,
Yep.
just in
Mhm.
case,
Okay.
is not a good idea.
Okay.
So, we were, and even through all that discussion, it wasn't abundantly clear why they were creating this district, so.
you know, and I can help you word something. I think you should just have a warrant article, should the town amend the zoning bylaw to adopt the limited industrial district as proposed in 1985 and as subsequently amended by future town meetings, question or act on anything related thereto. I think it could be that simple, and that's our placeholder, but at least it informs the public as to what the question is.
So what's the implication if that is not approved at town meeting?
Well, I think the key here now is to just get it in by December 1st, and then before any type of deadline to withdraw the articles, figure out from a legal standpoint how the Attorney General views it. And if it's possible that there's confirmation that based on subsequent actions of town meeting, it is in effect, you could just vote to pull the article and then it doesn't ever go to town meeting. So the goal would be to try to determine that it now has legal status because of how long it's been
Okay,
in effect, and then pull the article.
okay.
I mean, because one way or another.
That one? Okay.
I mean, that's a crazy one, isn't it?
Do you know offhand what the deadline is for polling?
It's up until they go to print on the warrant, pretty much.
Okay.
Up until the last advisory committee meeting. This is the one where you say, don't put it on your agenda to vote until we get much further detailed legal analysis on it.
Okay.
Because you've got, the zoning board's done that before, or
Yes.
even the planning board pulled it right up to the night that advisory was voting, so.
Okay. So are we finished on Article 1?
Yeah.
So my concern on the purposes that you've listed for Article 1 is that will have a direct constraint on our special permit authority. And I just want to make sure that we're comfortable with that, because we need to make a finding that the use is, it's in harmony with the general purposes, that's easy. Then the second is, with the standards of the relevant specific sections of the bylaw. So we will then have to say, and so if something comes in and it's residential, but it's actually higher density, we couldn't make that finding.
Right.
Well, so standards, I view as dimensional standards, and maybe not these broader purposes.
It says the proposed use complies with the purposes.
The general purposes? Or
No,
the
so
specific?
I'm reading 2B for the approval standards.
Okay.
The proposed use complies with the purposes and standards of the relevant specific sections of the bylaw.
Right.
So we would have to make a finding for the specific section that it complies with the purpose.
So if it's the term, like the lower density, the density, generally, Residence A is our most dense, Residence B is our moderate density.
Correct.
Residence C is our least dense, and that is inferred from the lot area requirements. But to the extent there's properties out there that already are non-conforming, they want to put a garage
Right.
on the property, the garage
would become a two-family or,
Become a two.
Right. But, so,
Or it's a variance
So
application
if it-
for setback,
So
like
they're only
my old
in
house.
front of you, right, if they need relief. And so.
but they need a special permit, so they come in.
For a two-family use.
Yeah,
so they're making
and we look at,
addition.
and it's in Residence C, and we
Yeah.
say, well, it's clearly residential, we
Yeah.
can use it, but this is not a lower density use.
Yeah.
So it doesn't meet the purpose
Okay.
of this specific section, so we can't approve it.
right, and that's why, that's why I don't like for residency that it was just lower density. I mean,
Yeah.
that may have been a subtext, and that may have, and that may be the practical effect, but I think if you go back to the town meeting when A, B, and C were established as A, B, and C, it's related to impacts on the water supply and with respect to septic and all those kinds of things. And I think that if that's the reason, then that doesn't, if the primary purpose is not just to create lower density, if it's really another issue, then you could get a proposal and say, okay, well, it was to protect the environment, whatever it is, septic system, and their addition or their, whatever they're doing, that needs a special permit or variance won't adversely impact, they can still do it. But if it's just because it's lower density, they may not be able to do it. So I do think that little bit more digging into the history is important.
Well, that, or maybe just eliminating the density references at all. I mean, they're in
Then
relation.
you've got no
to-
purpose for Residence C.
Well, right, and replacing them with something else.
I mean, because the other thing is, you end up, if you focus on density, you end up in a situation, again, speaking to the more densely populated areas of town, which are mostly the north end of Hingham, that it can always get more dense. There's never reason it can get denser and denser while the rest of the town
Right,
remains.
it's now consistent with making it more dense.
Which I think is contrary to the concern that everybody's raising, that North Hingham's getting more and more.
Right.
Well, that's our
dense.
higher density, yeah,
But I think Residence A, if you look at Residence A, I believe it's only in areas of town that's sewered. Right? So that was really the reason, and it's a more historical area of town where they're really, and most of the homes were thrown into nonconformity, the existing homes, the day it was adopted, because none of
Correct.
them, as you know, in North Hingham, the historic homes are on 20,000 square feet. So, I don't know, I just think it's a little deeper than
What about
this.
potentially deleting the specific purposes for each residential district and leaving just the general residential district purpose? I mean, I think there are clearer purposes for residence D and E. There's something different there that they're encouraging. They're not, those are for community development at like a whole project as opposed to individual house lots. With maybe more flexible permitting. So this doesn't have to go forward this year. This is something we can work on if it feels like it needs more work, or if you feel like it's something that we can work on through the process, then, we can do that tonight, or we could do that, over the next couple of months.
I mean, my sense is that this is a loaded section here going to the purposes, and it's going to attract residents who are saying, that's not the purpose, or that's not my purpose, and I moved in, and I'm not sure that we need to generate that controversy.
Okay.
Particularly since I did not, maybe I'm wrong, but I did not get the sense that what we have is not working.
No, this was just something to clean up, but maybe we could do it in a different way. So maybe it's a matter of cleaning up the general purposes. We have limited purposes, and it is something that it's a finding you make for every application
Right.
before you. So at some point, we probably do need to struggle with this.
I agree, but
Yeah.
so for example, what you have for D, provide for residential communities consisting of town, home development, and designated open space areas. Is that what D is limited to?
Yeah, pretty much.
And then E, provide for resident communities consisting of garden apartments, townhomes, and other multi-unit.
Yeah, that's it.
So D, so I'm comfortable with D and E.
A, B, and C is big too directly to the density aspect, though.
And it would seem to me,
Right.
residence A, B, and C,
It's the only way to distinguish between those properties is, but the
But it's
density
ambiguous,
speaks
though.
only to the lot area. And
to
to
the
the
size of the
extent
lot.
that there is no other coverage requirements, there's nothing besides setbacks that apply to those residential districts. Maybe density isn't the best. It is really how, at least I think about A, B,
I
and
agree.
C.
But the question is that how we
Is that
want to
limit-
guide
yeah.
our
Right.
decisions
Yeah.
going forward?
Right. But, I mean, you could remove the density reference entirely and replace it with something else, but I'm just not sure what that is. How do we distinguish between A, B, and C?
Well,
Or
so
do
for
we not?
example, you had, one distinguishing feature you have for A is provide for residential neighborhoods. B is simply to provide for residential areas with neighborhoods absent now. And then C, no mention of areas or neighborhoods. So is that, I just don't know if that's correct.
That is correct, though. Isn't that sort of,
That's kind of how I think about them, but it's not
It's
based
not-
on a
right.
record, right? Is that, I don't.
yeah, it's not,
The other question I have, and it just goes to how the bylaw is structured, is, so for example, the more recent, okay, and when I say recent, I mean 15 years. So for example, the FRD provision already has purposes set forth at the beginning of it. The mixed use in the industrial district, for example, Shipyard, has, it's only one sentence, but it has, like, this is why we're doing this. The two provisions that do deal with multifamily residential, which is 4E and 4F, they just launch into but is it more consistent to put it where there's a whole bylaw section about multi-unit development in Residence District D, to put the purpose in there?
It could go either way. So in the use table, those particular uses are subject to that section.
Yeah.
But there's no other section for residence A, B, and C.
Right,
I think
okay.
for consistency, to put the purpose of each district in
Yeah.
one place makes sense. But, it's just nice to have everything housed in one location
I
instead
agree.
of bouncing back and
I like
forth.
the idea of housing it in one location. I'm just not comfortable with
The current
the limitations.
language. Yeah.
So, so do we want to move forward with this as a placeholder, or,
take out some of the language?
yeah, I mean,
And then,
in many ways, I'm thinking that, I don't know, is the planning board the right board to say what the purposes of the various residential districts are versus us?
Yeah, I would imagine they would.
Susan? Or would you rather not even go down there?
It's a planning function. I mean, they've had some fits and starts on master planning, and I would think that this would fall under an umbrella. If you're master planning, you're looking at the purposes of your
Yeah.
districts and why you have them, and so I would think theoretically, yes.
Right, I'm looking to avoid stepping on toes unnecessarily.
Right, I mean, if you had identified that there was a consistent, something that maybe didn't come up once or twice, but you're consistent, like you have other articles you've proposed, where you see a consistent type of application and you say, we should really clean this up. I think those are the ones where it makes sense for the zoning board to pop in with zoning articles, saying, it's something we deal with all the time, and we see something that we think should be addressed.
We'll get to that in Article 4. Yeah, I should tell you guys that I went to the planning board meeting last week where they were talking about several zoning amendments, and I did say that we had begun thinking about something along these lines. And it's really kind of in response to the World's End, and where does that fit in the context of official and open space? And we got to thinking that perhaps it would be better to, or good, to be more specific if we could as to the purposes. So, I mean, there was no strong reaction either way. I know Jody Sneath kind of said, why do we need to do that? I said, I wish I could talk more, but we've just begun to think about this, so.
Yeah, and I guess, and I didn't mean it as like a kind of smart kind of question, is just at the beginning when I said, okay, why? And I think for even the planning board in particular, like when they're trying to figure out, do we go this way, do we go that way? I'm like, well, what is the concern, the planning concern that you're trying to address? And I think you've articulated that, but I think you always have to start with the why.
Right.
The public health, safety, and welfare why of why you're doing it.
And so what was so interesting in looking at like town meeting transcripts and past warrants is that it's never been clearly articulated what the purpose of, so it was an attempt at a cleanup, and I thought that it would be an easier exercise to insert language from the original recommendations made at town meeting for each district, but it was never really clear. So I do think this is really valuable, but this is maybe not the form that it needs to be. This is maybe not the time that it needs to happen, but it seems like for planning, we should always be very clear when we present zoning, or the town, whatever agency that is, what the purpose of it is, because it's what guides the permitting boards, for years and years to come.
I mean, so for example, let me just, if Residence A, if we revise the language to say, the purpose of Residence District A is to provide for residential neighborhoods and for general residential purposes, period. And then B, the purpose of the Residence District B is to provide for residential areas, period. And the same thing for C. The purpose of Residence District C is to provide for residential areas, period. So that takes out the density discussion, but does that make this now not useful?
Right, but then it begs the question of why do you need 3 districts if they sound exactly the same?
Right.
So it's almost like it creates more questions than saying nothing.
I agree. So I think saying it out loud, having removed the density, means that this just doesn't.
Why would we define those?
Yeah.
Right? Yeah.
So I don't think.
But I think adding the language that gets to the, if that indeed was why we have A, B, and C, is because of septic issues, sewer and/or septic. There's nothing wrong with saying that.
Is there
this
anything
is a
wrong with that?
resource protection.
Oh, that's a good way to
issue.
say it, yeah.
Yeah.
Well, yeah.
Resource protection, groundwater.
And that's a health, safety,
right.
and welfare
Right.
kind of concern.
And that's what Amherst does. They talk about resource protection.
So would you just insert that into Residence C
They
language?
say there's a lower density district that's intended for lower density development.
Right, but for this reason.
Right, correct.
Because I do think it's just, and maybe this is just more perception concern than anything, but the idea of we just want low density for the sake of low density sends a message.
That's right.
And if that's not what if that was not what it was, if there was some basis for wanting the lower density, I think it's important that when the public opens that up, they see, well, that's why they're having lower density, not just because they don't want a lot of houses or what.
Is there any plan to expand the sewer connections to various parts of town that,
Well, it has.
like similar,
Well,
like,
the thing is, the North
cottages?
Sewer District is a defined area, but it hasn't been fully built out. But areas where it's been fully built out, such as the Hull Street area, those are tiny little lots that are in a 40,000 square foot district.
Right.
There's no 40,000 square foot.
But they're on septic
But
now.
now they're on
They're on
sewer. They
not-
were
they're
sewered
on sewer.
back in early 90s.
Yeah, they're on sewer that's connected to Hull.
Right, so,
So now it's like, does it make sense that it should be redistricted?
But we'll leave that to.
Yeah,
the
but that's,
board.
Right.
that's another, I mean,
But isn't that-
when there was a redistricting of those houses on South Street because they were stuck in business recreation, when their neighbors were all in residence A or B, it made sense that they came and said, can you please redistrict this, it doesn't make sense. And the planning board supported that. I think sometimes you need the residents of an area to kind of also say, can you make this change for us, and, if it becomes an issue for them, but.
Okay, so let's wrap this part up. I would be inclined not to go forward with the purposes language, but I think we do need to make the correction to deal with that. To at least put the placeholder in for what may have been unintentionally done.
Did you get that language that I kind of blurted out?
Are you okay with that, or do we-
Yeah, I think there's some value to doing this. I think it would be good to clarify this. I don't think there's any urgency to do it this year, so I'm okay with holding off for another year.
So ultimately, when we vote, so we can move forward, do you have something that we can vote on for Article 1? It's going to be, we're deleting...
Or just renumber, just...
Yeah, we can add instead to, that we would, to create or to submit the limited industrial district, I'm sorry, I'm reading wrong, one, to adopt the district, the limited industrial district as proposed in 1985 and subsequently amended.
Right.
Subsequent action.
Yeah.
Okay.
Or anything related
So
to.
that's, I think, what our action item is for Article 1.
Okay.
Can I make a very small, but it makes a difference for organizing things later? Can you call it like ZBA 1 or something?
Yeah,
so that we
to the extent these haven't been submitted yet,
Yeah.
we usually have I usually say submitted by the zoning board.
But we'll call it ZBA.
Right, but if you call it ZBA 1 or ZBA 2, it's just going to make it a lot easier
Just to keep track of them.
keep track of them.
Yeah.
Okay. So that'll be ZBA 1. Okay, the record reflects. So now what's ZBA 2?
ZBA 2 is related to an article that's been proposed by the planning board, at least loosely related. So they are actually working on lot shape again. So just last year,
Right.
there were some modifications. We took a certain dimensional requirement out of the definition of frontage, moved it to the lot shape requirement under section 4. And at some point, the zoning board was proposing to delete the lot shape factor requirement, but during that hearing process, we thought, well, actually maybe it serves a purpose, and it ended up staying in there. Well, this year, the planning board is proposing to delete the lot shape factor requirement, and instead, in essence, to create a lot width requirement to a certain depth on the lot that I think was initially proposed to be the rear of the principal building on the structure.
There was discussion of moving that to the rear lot line.
I think that's what they finally proposed.
I think they're still talking about that.
It's what got submitted to I think they will
But what they
continue
did
to
is
have
they
that
did the
discussion.
more restrictive so they could always back off if they need to, correct?
But if it remains as a certain width to the rear lot line, our bylaw doesn't define what a rear lot line is, and so that's why we started to think about this. So there are lots that have multiple joints, and sometimes it's not really clear, well, which one's a side, which one's a rear.
That's right.
Sometimes you got little tails and there's really no rear line, you
Right.
know, the two sidelines.
So you're defining it
merge.
as to be the property line most nearly opposite and furthest from the front lot line, or primary front line in the case of corner lots.
Yes, so we also then had to define what a front lot line
Right,
is.
exactly.
What a side lot line is, for the most
The
part.
front line is the one that's most nearly opposite from the rear front.
Yes, exactly.
But in the case of a corner lot,
It's along the street. For a lot of our zoning districts, it doesn't really matter.
Right.
We don't need to distinguish between side and rear, but there are, and particularly in industrial, office park, and some of the waterfront districts, there is a difference between what a side yard setback is versus a rear yard. So this actually is something that would be valuable even if the planning board's bylaw is amended and it isn't measured to the rear property line. So that's what 3 of these definitions are in the item 1. The first definition that was inserted is a definition of lot area. And so there was also a concern that somebody had proposed, a resident had proposed to the planning board that their lot width requirement is intended to meet, but they had left on the table a concern about tails of lots. So while it's nice that it create, a particular lot width to a certain point on a lot will create some uniformity, there's still going to be some lots that have strange tails or little corners that jut off of it. And there's some concern that those areas should not be, not that they can't exist, because there will be some, it will just happen, but that they shouldn't count towards lot area. And so this is language that's quite a few other communities use, Concord, Newburyport, to name a couple, that would exclude those areas between 2 points that are connected by a line of less than 50 feet. And there are some diagrams that we could insert to help people understand that, because I think when you read this language, it can be a little bit like lot shape vector. Roger has offered to work with us and throw something together in AutoCAD that we can insert down the road. So that's that. Item 2, we did insert one diagram, and I would see potentially another to depict lot area. This is replacing an existing diagram we have, because in that diagram we don't distinguish primary front lot line.
Where is that?
It's on the very back, right before the index, page 116. So this would replace that second diagram. Only to, and we can make it look more like the first one. I don't think the particular font.
Actually, I like what you did better than what's here.
Yeah. Thanks.
Which one do you like? What, this one, rather than
Yeah.
this?
It's like an Excel spreadsheet
Yeah.
attempt, yeah.
Glad I had done that.
They're both confusing to me, so.
The intent is to make it clear.
I'm, maybe it's gonna evolve. I guess I'm just confused or concerned about, I don't know, maybe they're intended, but maybe more unintended consequences of the full width of the frontage. Are they talking about the full width of a frontage?
80%.
80%.
So it's similar to our circle
80%,
requirement,
yeah.
but now it's taking away that shape, the circle,
Right.
and just requiring a certain.
So
width.
this is your frontage, but it could, one side or the other, or both, could kind of dip in
Yep.
for the whole, so, but that's 80%. I mean, if, what's our frontage, 150 feet?
That's the planning board article.
Yeah.
No, that's, but I'm saying this, if that's where they go, then you could never create a lot that has a distance of points between the lot lines of less than 50 feet. Do you know what I'm saying? Like, how do
Create
you?
that lot, and then at the end it would do.
Yeah, you could,
a
there's enough
tail,
area.
Or it'd have a little corner or something. And so what this definition of lot area does is it just excludes those straggly pieces and little elbows from.
But the property line most nearly opposite, I guess I can't follow your definition then. The property line most nearly opposite, what does that mean? And
So-
furthest
yeah.
from the front lot line.
So let me draw.
Okay,
a
the,
picture. So-
because if your rear lot line is the furthest from, what if it's all of a sudden it really skinnies down a lot? Like, how could you get this?
Well, so this is your rear lot line, right?
Yeah.
And you'd have to, this would have to be 120 feet.
Yeah.
This is 150 or more.
Yep.
But this has to be 120.
Yep.
And if this is less than 50, then this doesn't count towards your lot area. Or.
So this is the language from Concord, isn't it?
So basically what it's doing is, it's getting skinnier, but then it's getting wider again?
Yeah, or that little tail might be anywhere else in the
But
lot.
what if
Doesn't have to be at
it's,
the rear.
what's really going on in a lot, and hang on, in a lot of lots where it's coming and then it's really doing one of these funky things?
Right, so.
So where's the rear lot
yeah,
line?
There's gotta be something.
It's shaded in black.
If it's a
See?
curve.
I don't see it in black.
But if this is an angle, so then this, it would be nearly opposite, I read as parallel.
Okay, I'm just concerned about the rear lot line definition.
So, but it seems to me that the planning board is pursuing its zoning article. And so the timing is right for us to be addressing this.
Right.
And so I think to the extent that we're voting on this knowing that it's going to
Yeah.
be subject to modification, I'm
Yep.
comfortable with it.
Yep.
But this, I think we should get resolved in conjunction with what the planning board
They
is
have to
doing.
make sense together at the end of the day.
Exactly.
Yeah.
Okay.
So my sense is that we should proceed, and I'm not sure we're going to iron out the geometry issues this evening, but it needs to be resolved.
But I can see where this language came from. It's in the
Yeah.
Concord minutes.
Yeah.
Right.
Concord has a pretty good bylaw.
Yeah, they do have a good bylaw.
Yeah, there's somebody in.
And they have that lot width
I don't know how you
thing too.
do-
Yeah.
80% of the lot frontage back to the front of the building.
Right.
Well,
And so,
Front of
or
the
even to the
principal
front
dwelling.
of the building, right.
Front of the principal dwelling.
That would be problematic
Right.
here because of our established front yard setback exclusion, where the front of the building is, if it's, the intent of uniform lots is really to provide access, maybe you need to create a certain width all the way to the rear of
Right.
the.
Yep.
But I think so I'm the one who, I pulled the 20, the 19, the benchmark towns,
Yep.
just to start with. They don't always match up for zoning purposes, but it's a benchmark that advisory is familiar with and a lot of selectmen, et cetera. So,
List of those towns somewhere?
excuse me?
Did we get a
Yeah.
list of those
Yeah,
towns somewhere?
I have the list. Do you have it? Emily, I
I'm just
forwarded it
curious.
to you, right?
I mean, I know it's like
Yeah.
Wellesley and Concord and.
Yeah, but then there's Situate's in there.
Situate and Needham.
You know, yeah.
Okay. Yeah.
But I would say the overwhelming majority of them, if not all, but I'd say, 90% of them, it was to the center of the building, the back, the rear of the building. I don't really remember seeing any, maybe one or two that was to the back lot line.
Right.
So just as a matter of kind of benchmarking what's typical in other communities, almost every community, with the exception of maybe two, had the lot width but they varied between, say, 75 to 80%. I think maybe one had the full frontage, but I don't really remember them going all the way to the back lot line, but for what it's worth.
Okay, so I think my recommendation would be to proceed with Article 2 as drafted, knowing that it's going to be subject to change as the
Right.
hearing is complete.
Yep, I would agree with that.
ZBA too?
ZBA 2, I'm sorry.
ZBA
you're
2,
right.
exactly.
Move on to ZBA 3.
Okay. So 3, what is 3? So 3 was in some ways related to formerly ZBA 1, now 0. So this is an attempt to clarify that open space is in fact permitted in the open space district. So since we don't have purposes, and that use isn't necessarily highlighted in the use table presently, this seeks to solve that. So item 1 would delete from the current public municipal use 3.5, the word park, and move it into a new use that includes, in addition to parks, playgrounds, open space, and conservation areas, none of which would be qualified by the public or governmental ownership or use limitations of 3.5.
So this is strikingly similar to 3.5, is that what you?
No, it's deleting.
It's deleting just the word parks, sorry, it should delete the word and parks.
Yeah.
So right now, there is no 3.12 now. This is a new thing. What I'm saying, so what is this, are you, you're not changing the other.
Just changing 3.5 to take out the word park.
Right, and what I'm saying
Yeah.
is that this looks almost exactly the same as you go through the conditions of what's permitted or not, like 3.5. Is that?
No, except it's A1s instead of A2s, which I don't think the planning board's going to go for.
So-
Either way, I mean, public premise, maybe
So
not.
I get, that's what I'm trying to
Yeah.
understand.
What the use is, where it's permitted?
What are we, if model is the right word, what are we modeling the allowed, permitted, or special permits on it?
3.5.
So it is 3.5, right.
Yeah.
So I think, as I see it, you tracked 3.5 into 312.
Yep,
Other than changing, you've made a couple changes.
yeah, I made,
You've
I
changed
changed
it
A2s to
A1,
A1s.
and then the second one was permitted. So the second A2 for waterfront,
Yes.
you
and-
changed from an A2 to a P.
And I did that because it is surrounded only by other official and open space property. So that is only on the back river, on the very far side of Bear Cove Park. And it seems that there are not likely to be any community concerns that this board would need to work with on that.
So I'm in favor of breaking out there's an issue with putting parks, I think, in the same category with a DPW or
I
a light
agree.
plant
Right.
facility,
I
right?
agree.
So I do think that that's something that needs to be addressed. I think there's some history I've heard about, although I haven't looked into myself, about how official and open space came to be, but I don't think it was necessarily from a good planning perspective that it came to be. Here's my unintended consequences concern. I think and I just, because I work with the Conservation Commission whenever they're picking up conservation areas, I don't, if in, for the sake of argument, official and open space, there's a parcel, let's say, for example, I mean, to make some, let's say for the sake of argument, they decide we're just going to transfer control of the selectmen's parcel to the Conservation Commission. And now, so they go to town meeting, say, we're never gonna build anything on that, let's just make it conservation land. They need a special permit A1 now? So I think that the concern is more for improvements on these lands, not to have a conservation area. If all, and the town gets, a few times a year, the Conservation Commission picks up land through gift or otherwise, and do you need to get a special permit just to have something stay in its natural state? So I'm just, that's, I think, is like, maybe, it's really,
Allow it by right wherever, I mean, or we could change this to buildings associated with parks, playgrounds.
well, I'm almost thinking,
Or parking
like-
lots, but that should be done by the
So
planning board.
what I'm hearing is an official and open space, put a P with a special condition that to the extent that there's new construction, it needs an A1 or A2, and I'm not sure which is the right one. So that handles your concern, Susan.
well, or is it, how under residential, there are accessory uses?
Right.
So what if parks, playgrounds, open space, and conservation areas were permitted in every district, and then there's an accessory use, which is structures within these uses, so you build a structure, now you need an A2, right? So under accessory uses for residential,
Is it an
don't
A2 or an
you?
A1? What's the
Well,
right-
whatever. I mean, right now it's A2. I just, I don't know. You cut.
Well, you say it's an A2, but if we look at, at 3.6, 3.7.
Oh, only in official and open space, it's an A2. No, in
Only if
3.5.
it's a public building
It's
and
an A1.
premises for government use, including public libraries, museums,
Right.
and parks, is it an A2?
A2, right.
If it's, it's an A1, if it's
So it's an
a
A-
country club,
Right.
if it's a.
Private
community-
Does that
nonprofit,
make any
it's an
sense
A1.
that a country
No.
club is an A1?
Right, well, and it's much less intensive than a wastewater treatment plant or a DPW
Yes,
or a light
yeah,
plant, so
yeah.
an A1, I think, makes sense.
Okay, well, I
Or
mean-
anything, it could just be permitted.
Okay, so I have no opinion or, dog in the fight as to A1s versus A2. The question is, should the use itself
Yeah.
just be permitted, and then accessory uses, which are, when you're building a visitor center,
Yeah, it's really
those, like you're making improvements on it, that's what's gonna have the impact, is the structures.
So let me understand. So if we have a park, official and open space, and we say it's permitted, and then we want to build a park ranger hut, is that accessory, or is that actually the primary purpose? It sounds to me that that's not accessory, but I think those are the circumstances where we want the permit. So I wouldn't limit it to accessory.
I mean, what if, right, but what if you had parks, playgrounds, open space, well, playgrounds by its definition is going to involve structures. So
Like
what
the
if,
jungle gym.
right, so what if, because you have, 1.1 single-family dwelling, and then we have 1.8 accessory uses when in conjunction with a single-family dwelling and two-family, right? And then you have all those subsections. So what if it was parks, open space, and conservation area when, unimproved, but, you know what I mean, that are unimproved? And then you have 3.13, which is accessory uses in conjunction with a park, open space, and conservation area, and that's structures, or, because I think nobody's gonna mind if you turn land behind their property into passive open space.
Right.
They are gonna get concerned if all of a sudden that passive space has visitor centers and,
But now we have, right, so I was sort of envisioning the visitor center potentially still falling under one of the other uses. So we've got the private nonprofit community center, or all of these definitions could use somewhere, or uses. I think that approach makes a lot of sense, but we would have to be thoughtful about what those accessory uses or structures are, and I don't know that we can contemplate every one right? So,
but do you need to? Can you just say buildings or structures in conjunction with those uses need some sort of review? I mean, right? Because how do you do, so let's say for the sake of argument, 3.1.2 is this use, it's permitted. Okay, so let's just take, for the sake of argument, the Laner property. Now that's gonna have a conservation restriction on it, so it's not really gonna fall under this, but the town's gonna own it. Right now, it's zoned residential. It's not official and open space.
Right.
It's permitted as of right, so.
right, and it will be once we move it into official
Right.
open space.
Assuming we do.
Assuming we do it right, I understand the town's gonna come
So
up with
has
more
anyone
money.
thought this, and I mean, the planning board, that's gonna get acquired in January.
Yeah, I know.
But there's no article by anybody to move that land to official and open space.
Again, there's no purpose for the
And no-
official
and
open
nothing-
space district.
Right.
So it doesn't really matter.
And, it's gonna have a conservation restriction on it anyway, so no one's gonna be building an amusement park on it. But,
Or a 40B
I
development.
don't want to overcomplicate this. I don't want a situation where all of a sudden a conservation area needs a special permit to be a conservation area. So what is it's the building, it's the improving of these areas that raises concerns.
So 3.5 I think it's odd in a use to say the buildings, but 3.5 does say public buildings and premises. Could we do for this category buildings?
Public buildings and premises for government use, including public libraries, museums, parks, and you want to add,
No, I would just take the concept of taking the word buildings, not public, and throwing it into 3.12. So buildings or structures associated with parks, playgrounds, open space, and conservation areas.
would require the
So
permit.
just make one use, but the use is limit, I think, again, it's odd to put the structure on the use table, but I think that it makes sense that we only want to really regulate those and not others. I just want to make sure it's clear that we're not, clearly if we're allowing the buildings in connection with those uses, we're not prohibiting those uses because the uses aren't called out separately.
But if 3.5 is public buildings and premises.
Right.
So this technically governs parks even if there's no buildings on it.
Like
Correct.
Whitney Wharf was built out, nobody came and got a special permit,
Right.
A2, so it's
Right.
not.
Right, so
It's not really
3.5
being applied,
Right.
right?
Mhm.
Right.
But is that not a good
there-
thing, that you're creating a park and
It's a great thing.
the zoning permits not being, the zoning bylaws kind of being
Well,
ignored?
there's no, there's no qualitative change in the use of the property. If it's like vacant land and then it goes to a park and there's a bench put out there, they're not going to the building department to get a building permit. There's nothing that would trigger the need for the permit until they make improvements. So by default, it would be the improvements that brings them in the door. You know, either for site plan review.
Well, right, or
possibly-
alternatively, you have
Yeah.
someone who asks the building commissioner for enforcement action, because it's not being used properly, he says no, and then it comes to us to
Right.
resolve.
Right.
So there wouldn't have to be any construction.
I mean, I generally am in favor of this concept. I guess the question is, does it adequately get to what you're trying to get to?
Well, I think, I mean, these are low intensity, low impact, probably.
Well, I don't think there's
uses.
some neighbors in World's End who would agree with that.
Right.
True, but they're building a community center, so they're in for a permit for that. And so I don't know that World's End.
What are they coming in under for that?
That's what we had a long discussion
And
about.
so what is it? What is the answer?
I think a consensus.
3.6, I think it settled on 3.6.
It was,
A nonprofit community center?
Yeah.
yes,
Visitor center and the related parking circulation.
they came in on a 3.7.
Maybe that should be revised to museum, community, or visitor center. But,
They came in under 3.7, and I did not like that. Because any suggestion that it's some sort of
Club.
Club.
country golf,
Right.
swimming, says, or
Well, it's membership based, but yeah.
it's
yeah, but
very-
anyone
that's
can go,
not-
though.
Right.
I don't get the not conducted as a business at the end of that. I don't know what it
I
means.
know, it's-
But,
I think this whole section doesn't really
Work.
allow for commercial uses, and at the end of the day, our zoning doesn't necessarily, it shouldn't care about whether it's a governmental
Exactly.
owner or a
Nonprofit,
nonprofit or a
right.
business. It should be about the
Use.
use itself.
Yes.
But that's for another day.
Yeah. So what are we going to do with 3.12?
I mean, do you, yeah, I don't know.
Do we want to move forward with this? Submit it as written and we can change it? Is it restrictive enough?
well, what if
Yeah,
you
you-
called it
yeah.
buildings or structures? Or,
I'm fine with that.
I'm
I
not
mean-
sure what the it is. What are you proposing?
3.5 has, public buildings for government
Right.
use. So what if it was buildings,
Buildings and
buildings and
premises or parks?
structures? Or what about buildings or structures in conjunction with parks, playgrounds, open space,
Would
or
that get
conservation area?
into, would that cover, say, you got to build a parking lot to service
No,
a new
but
conservation
the
area?
planning
Or
board
that
does
they would-
parking
parking.
determinations and site plan review, so those types of improvements, I'm relatively confident there's another agency that would be reviewing that. But, unless they're in conjunction with a building or structure, and then
Right.
you could issue a special permit.
Right,
or-
okay. All right. I just want to be sure.
Again,
Get going with buildings and structures.
3.12, are you saying that it should say buildings and structures associated with parks, playgrounds, open space, and conservation?
Yeah.
So if that's the case, and you have open space with no structure, are you saying that there's no place in the?
Yeah, how's it governed by zoning?
Yeah,
Again. if
I
we-
thought your purpose was
yeah.
to in fact
And
allow
that's why,
that.
Yes.
that's why my thought was originally make these all P, but then take playgrounds out because a playground can be in a park,
Yeah.
and make 3.13 buildings in conjunction with, so this would be unimproved, 3.112 would be unimproved, 3.13 would be kind of the accessory, like the structures in conjunction with, requires a further level of review.
So your example, which is you've got a property which has a hut on it, has a structure on it, and someone wants to put it into conservation, make it conservation, now you have to get a special permit because it's got a structure? Is that what you're proposing?
Well, it would be non-conforming.
Well, if you just change the zoning,
Yeah, we
it
wouldn't
becomes a
require.
pre-existing non-conforming.
Right, yeah, we wouldn't require.
It doesn't have to get a
permit
special
for an
permit if
existing
it's already
structure.
there.
Yeah.
It's just pre-existing non-conforming.
Yeah.
I'm just viewing this as, the point is, make it clear that these are the uses that are invited and allowed in the town, because they provide amenities, benefits to the community.
Okay.
But if you're gonna start building them up, you might have impacts that weren't intended, and now there should be some level of review.
And if a property becomes a park, and then they're going to designate a portion of that for parking, there's no structure, so then it's still only under 3.12, and so whatever they do, as long as there's not a structure, it's permitted.
Well, I think to
I'm not
create
sure.
parking, aren't you gonna end up under Section 5, Article 5?
You'd be getting a special permit A3.
Well, that would be,
Because-
Unless you meet the parking,
There is no parking requirement for a park. Okay. So you'd be getting a special permit from the planning board for the parking.
What requires them to do that?
The fact that there's no parking
If you wanna
requirement for parks, playgrounds, or open space.
Is it Article 4?
there's no requirements, so.
So if there is no requirement, any
You have to
use
get-
that doesn't have a requirement is required to get a special permit A3, a parking determination. It's not,
They can't claim it's accessory. Okay.
it's any use that's not listed, and it's a very small list of
Right.
uses that
Okay.
are. It doesn't mirror our
Okay,
use table.
okay, then I'm comfortable with that.
Yep.
Yeah.
Yep.
Um,
And as we said, it might be picked up under site plan review, too.
Yeah,
Yeah,
sure.
okay. So we're saying 3.12, make it all Ps, and then do a three.
I would say unimproved.
Right,
Unimproved parks, open space, and conservation areas, and get rid of playgrounds. The playgrounds by their nature are,
have an improvement.
Unimproved mean? So if it has park benches, it was landscaped, what it,
Yeah,
I know what you mean.
Yeah.
But
how do you write that?
What really triggers,
Yeah.
whether something's improved, when it has stormwater systems, I don't,
Park benches and lighting and
Are not-
trash
right.
cans, that's, so-called street furniture. I think you could exclude that.
well, I like being more precise too, but do you want to throw in unimproved, and that could always be clarified during the
Do we
discussion?
Yeah.
have to include that term if in the next use we're gonna say structured buildings or structures?
Well, arguably.
Well, I think you got to take playground at 3.12, because a playground, by its very definition, has structures in it.
Right.
Parks, open space, and conservation areas.
Can I ask you a question? What would you call Lynch Field or Carlson Field?
I would say that's improved.
Is that a playground?
No, it's a field, right, or a park, an athletic field. Should we need to include the word field? Parks.
Athletic fields?
I was thinking of this more as passive recreation, but maybe we need
So maybe it's
to think about the.
parks, open space, and conservation area, and 3.13 has to be more than just,
Yeah, maybe playgrounds, fields, and structures.
Right.
Buildings or structures associated with
Right.
parks, open space, and conservation.
So does active recreation capture?
so once it goes to active, once it goes from passive to active, I guess that's what the trigger is, how you word that is
Yeah,
the,
with passive, it's like walking trails,
Right.
overlooks, benches, things like that.
right. I think that's the distinction we're trying to draw, I guess,
Yeah.
is passive versus
Just
active.
true.
So here's where I'm at on 3.12, which is what's drafted here is not ready for prime time.
Yeah.
Do we want to try to go forward and improve this or not go forward at all. And that's, because it's clear that this language does require further refinement. Do you think we can get it refined in the hearing process? Or again,
Let me ask you a question. There's fundraising going on to put a playground down at the harbor in some place on the harbor. Now that's waterfront. No, some of it's official and open space. It would be on official and open space. So would that require an A1 or any kind of review? I'm not saying it should, I'm just asking the question, would it?
I think this change.
Under
that
the
we're
current,
talking
no,
about
under the current
would,
bylaw.
But under the current bylaw, there's been the way it's historically been interpreted is that property is already in governmental use, and so they're just putting another.
Right, so for example, when Crest Field completely redid their playground, and when Bradley Woods recently, with CPA funds, completely redid their playground, there was no site plan review. Was there a site plan? Oh, because it triggered the dollar amount. So there was a review.
Yep.
Right.
Yep.
So I guess that's the question. If a review is going to be triggered, what's the trigger these days? 25,000? 20,000?
It's not that much.
Okay, well, I do think this trying to clarify this is a worthwhile endeavor. It's up to you guys whether you feel like it's ready to go or not, or whether it's far enough along to submit it.
I'm into that. I'm pretty sure we could get there, but it's not there right now. So if you want
My real concern is that this will get caught up in the World's End controversy.
Yeah.
And I'd rather have the discussion in a
Yep.
dispassionate way.
Yeah.
Yep.
So
I
I would
definitely agree.
recommend that ZBA 3 not
Yep.
proceed.
Okay,
Yeah.
that makes sense.
I would agree with that.
Okay.
Timing.
Well, so the next.
ZBA 4.
ZBA 4 is.
Let's wrap this up.
Related. But not directly. So this was proposed because, well, we've recently noticed in reviewing early plans for public projects that a number of them will require relief from our maximum building coverage requirement.
Because in official and open space.
In official and open space. Because the requirement is very low. So official and open space only allows 10% lot coverage, which is less than any of our other zoning districts, some of which have no maximums, that are residential districts. And, you know, others range from 25 to 50, basically. So it seemed potentially overly restrictive, and it was something that we hoped to modify to at least increase it to what the next lowest district was. However, because we merge official with open space uses, a higher threshold maybe isn't appropriate for those open space uses.
Right, for recreation areas. Right.
So this is an attempt to distinguish between the two. So what it would do is in the dimensional table, so.
But then
What page
it
are we
screws
on?
up your 17.
Yeah, so.
We're on page
they're all a
50.
little bit related.
50 and 51.
Page 15?
50
50.
Yeah,
to 53 is where the special requirements
So
are.
that middle column right there has a 10% requirement or maximum limitation. We would replace that with a 10%/25% and then add a new special requirement, number 17. So the final column would include now 1, 2, 5, 6, 15, and a new 17. And then the new special requirement 17 would say properties permitted under a use that now will not exist shall maintain a maximum building coverage of 10%. All other permitted uses within official and open space district may maintain maximum building coverage of 25%. So if the board were inclined to think about this, we could just allow 25% for all. I think there's probably minimal risk of any open space areas because particularly based on their large size, to ever want or need to build to that level.
Well, if you have conservation land, then they're somewhat restricted by being conservation land, particularly if they have conservation restrictions on them. I'd say where you might have people concerned is, for example, down at the harbor, right? They're not gonna want, now granted, there's already something proposed, it's relatively modest, it hasn't come forward yet.
Yeah, it won't approach.
It won't.
It won't approach 10%.
Right.
But still.
But I think that's where you're gonna hear people saying, well, you don't want a building that's gonna take up 25% of a harbor parcel, right? And I think that's where, so this was kind of my idea, was to come up with this bifurcated approach.
I don't understand the 10%/25.
Right.
What does that mean?
It would be depending on, see, that's because official and open space is such
Right.
a wacky district.
The 10% is open space, the 25 is
Official.
official.
But it's
So-
Official use.
So a DPW
Because we merged the
could,
two in one district.
a DPW could have 25% lot coverage, but if you're
Right.
talking about, I'll
Or
just use the
library
harbor,
or
you're
the
not
fire
gonna.
station
Yeah,
or
but if you're talking about the harbor, you're not gonna
Right.
put,
Correct.
you're not gonna exceed 10%.
But it's all in
The
the same district, so
Same
how do we
district.
distinguish?
So,
I'm missing that.
Maybe a
Right, well-
different
Well,
approach would be
that goes to the
put a-
previous question as to how we
how we
modify.
distinguish between the uses.
Yeah.
Which we don't right now, but you're right, so if we distinguish between the uses, you could put a
That-
special
exactly,
requirement
right.
on the use, which is, I like all the dimensional stuff being in the dimensional
I
table,
agree.
but we do have other examples, like for instance, that special requirement that requires 2 acres for veterinary uses in certain districts, or,
Yeah.
whatever. We have special requirements to certain uses. But now we only have one use that lumps all those things together. So that wouldn't, so based on the last discussion on Article 3, the slash doesn't really work.
So, I mean, the problem is that and again, you can't zone around specific projects, but I think this is something now that's becoming a recurring issue, is that the town is held to a different standard than private owners for similar type projects. So, and there are some projects in the foreseeable future. And so you are gonna potentially end up faced with variance requests, which may put you in a very difficult
That's
position.
very difficult, I agree.
But we did want to recognize the concern about the open space areas and then.
Well, I'm just trying to anticipate what a person may raise a concern about at a hearing or at a town meeting floor. So,
I can see the logic, I can see the rationale for doing this, I agree with it. I think it's got to be tied to however we handle the open space
I agree with you,
question.
Joe.
yeah.
So we can precisely say this section and this section,
Yeah.
10%,
Yeah.
this, it
How
can
do
be
you-
up to
How do
25.
you distinguish lot coverage between permitted uses in the same district? That's the problem.
You
Right.
have to put a condition, you have to put a special requirement on the use as opposed to in the
Right.
dimensional
Right.
section.
Right.
Yeah. And then eventually you need to separate those into 2
So maybe
separate
not do
districts.
this,
Not do the special requirement 17 here if we had a use for parks, playgrounds,
It's
open
open
space and
spaces,
conservation
right.
areas.
Right,
And/or structures associated with them, well, particularly with structures
right,
associated
the
with them.
structures, right.
Then you'd be putting it in the table of uses.
Yeah.
Next to that use.
So,
Sounds like we should not pursue this one in its current form?
I agree.
And, yeah, okay.
okay, so, is that, what's next? Is that it?
Nope, so then Joe.
Oh, now we do the,
Well, this is our, yeah,
Oh,
our
non-conforming
non-conforming
accessory
accessory.
structures.
Right, the one we tried to get, was it a year ago or was it 2 years ago?
Both, as a matter of fact.
why are there two?
Well,
Time
so
flies.
what you have in front of you, this hasn't been changed at all. These are last year's. the one that's in the same font that you've been looking at, the proposed Article 2,
Yep.
is what you proposed last year.
Yep.
The one in the funny font.
Yep.
Is,
I'm sorry, can I just interrupt for a second? You guys have this one well in hand. I appreciate you letting me sit here and give my 2 cents, and I hope I didn't derail
It was
anything.
exceptionally valuable.
Oh, good. No, I hope so. I didn't mean to derail. We didn't talk about these ahead of time, so I had no idea, and Emily did not know what my comments were going to be. So I didn't mean to throw any curveballs, but if it's okay, I'm going to take off and leave you guys to your non-conforming.
Thank you, Susan.
Thank you.
Thank you.
Yeah, so the funny font just takes out what's
it does.
paragraph
So
3 in the standard
This is
font.
what the planning board recommended last year that
The
you eventually withdrew. So
the funny font,
I
yeah.
offer it only as, just as a reminder where this left off with the planning board.
Right,
And
so-
they were supportive, of this, but the board felt that this wouldn't really accomplish what they wanted. So
what's missing in between the two is
any expansion of a detached accessory
Roman,
structure.
this 3?
Roman numeral 2, R2.
Oh, R2, I'm sorry.
Yeah. So they were comfortable with garages, for instance, being rebuilt in the
Right.
exact same footprint.
Right.
And a very modest expansion of
Right.
attached accessory structures, but no expansion of the detached accessory structures, which is what the primary purpose of your amendment was for. I mean, in fact, limiting it to the footprint of the existing structure doesn't even allow for it to be moved into a more
I know,
conforming
it
location.
doesn't make sense.
So Joe, I think because we've seen another year of a number of applications that would be covered by this.
I mean, if I actually sat down and counted the number of variance applications I've personally sat on over my years, I'd be shocked,
It's a lot.
That these could, I mean, they're de minimis. They're usually in keeping with other structures in the immediate neighborhoods. I mean, there's really no reason other than our zoning is so restrictive in some cases
So
that they need the variance.
would you propose re-proposing what we did last year?
I would, yeah.
I would
And I've
support that.
invited some of these skeptical members of the planning board to come sit and observe us some night as we go through a number of these applications.
Yep.
And I've got one of them to agree.
What I would offer is that I have some concerns about going back with the same language that hasn't gotten there a couple of times, unless there's something new about, maybe it's just continuing the educational process about
Correct.
what you experience.
I'm willing
and
to take a
there.
crack with the language that we've tried to get through.
Yeah, the language is
Because I
right.
think that
Yeah.
addresses what we think is a real need here.
What's the pushback?
That, non-conformities over time, we'd ideally want to eliminate. These are unique. A lot of communities treat non-conforming accessory structures to single and two families in a different light, either as a special permit or by right, or create carve-out exclusions.
That's correct.
Similar to what we do for sheds. You can have a 64 square foot shed within 5 feet of a property line. Oftentimes, communities will do something similar, but for a 2-car garage, even if it's brand new construction. So we just don't we're very generous when it comes to the single and 2-family structure itself, but not with the accessory structures there too, and it's made people kind of contort themselves into weird development plans over the years. I wondered if there was any way to reword this to limit the maximum area of incursion or something that maybe the board or the advisory committee would find more compelling than what we've done in the past. It seemed like, if it's not increasing by more than 25% the area of incursion, as opposed to 25%, particularly for accessory structures, attached accessory structures, a 25% increase of a 50 square foot front porch is meaningless. I mean, why would...
So, as I understand it, you're talking about little 3.
Right.
Little 3,
Okay,
yeah.
which is, the 25% is in the funny font version,
It's in both,
which
yeah.
they're fine with.
They are fine with it.
So-
I just don't know that it really accomplishes your goals.
Okay, so
Yeah.
I thought our purpose here was to address the other section where there's been objections to.
Well, I think initially, so maybe if we step back a whole year, Little 3 was not what Little 3 started out as.
I agree.
It used to be merged and everything was 24 by 24, and it was only this board that said, ooh, maybe we don't want a 24 by 24 front porch. That's too big. So we applied, a different standard, but maybe that standard wasn't the appropriate one.
So do you think we should just go back to?
I think it may be worthwhile, again, trying to merge 2 and 3 into something and not limiting it to a particular dimension, but rather to a maximum area of incursion over what exists. Does that make sense?
Yeah.
So it's
I see what you're saying,
relative to what's there, and it gives the property owner flexibility to pull the structure away from a property line.
So that makes sense. How do we write this?
Because I think that's kind of how we look at these
Yes.
things. If it's a
Can you say the
de minimis
resulting
intrusion-
footprint does not exceed a certain percentage of the existing footprint, right? Or is that just contorted?
I mean, it still probably has to have that, does it still have to have that language in there about not further reducing the minimum linear measurement of the existing non-conforming dimensions? So we don't want it to go closer to a property
Right.
line, even if the area of the structure is getting
Right.
smaller.
Right.
So that probably still needs to be there, A.
Yep.
We want to change the footprint, and instead for B, we want to say that the resulting area of incursion shall not exceed X.
125% of the existing incursion.
The existing incursion.
Does that make sense?
So you're in 2?
Mm-hmm.
2B, yeah.
Yeah.
So we're getting rid of the 24 by 24?
Yep.
Yep.
I agree.
Yeah.
Yeah.
Yep.
And it's not the footprint of the structure, it's the footprint of the incursion.
Yeah.
Incursion into the applicable setbacks.
125% of the existing
Or it's no greater than.
incursion. Okay.
So the part that does not intrude, there's no limit.
Right.
Correct. Other than a building.
I like that.
Yeah.
And then we would apply that to both detached and attached?
Yes.
I think we should, but we got the pushback on that we should treat them differently.
No, that was originally you guys. It wasn't pushback from any board, it was that you felt that
You wanna get this
24 by 24 front porch would
Porch was
be
too big.
crazy.
I agree.
Yeah, so we broke
Right.
it down.
Okay,
And then, but then it got into a weird place.
Okay.
And then still keep the height, because that seemed to be something that was important to
Yes.
the members of the planning.
Yep.
Mm-hmm.
So
if
height
we
is not
merge-
something that qualifies attached accessory structures, but it probably should. You can have a, I don't, you're probably
Right.
not going to have a
Yeah.
two-story covered porch.
I don't
but
think it's going to have any
nonetheless,
practical effects, so.
yeah. Okay.
They're out there.
Are they? Yeah, okay.
They're not very attractive, no. Trying to fix them.
What about leaving 4 in? So 4 does require,
Extended alteration.
that changes the finding that you would do presently to a special permit.
Extended or altered portion of the accessory structure. Are we trying to say it's the portion that's not in setbacks?
Yes, so this is for the garage, but it's in the setback fully.
Right, it's only a
but-
piece
Right.
of the garage, yeah.
But they want to put on a shed addition that itself would comply with the bylaw. That needs a finding presently. But this would make it a special permit. And either way, it's the same process
It's the
for you
same
guys,
pro-
it
I'm
just
fine.
applies different
Yeah,
findings.
I'm fine with that.
Okay.
Yeah, yep.
So that would become the new 3.
Yes.
And we're deleting from item 2,
we'll delete A, detached, and change it to the accessory structure. Does not further reduce the minimum linear measurement of the existing non-conforming dimensions or create new non-compliant dimensions. B, the resulting area of incursion is no greater than 125% of the existing incursion.
Yep.
And C, the resulting height doesn't exceed 1.5 stories.
Yep.
Okay.
Good.
So it's a little bit, it's.
Right.
Yeah, I like that.
Okay.
Right. It's a minimum.
Yeah.
Right. I think it's pretty consistent with how we've done it.
Design freedom too, because we get these all the time. I get these all the time.
Right.
So then I'd accept the motion that we, I guess this is a motion to adopt and forward to the planning board? To the Board of Selectmen. ZBA Articles 1, 2, and what will now be ZBA 3. ZBA 1 is the amended language, as we've discussed, that deals with the official open space recreation district? No?
No, limited industrial.
I'm sorry, limited industrial. I looked at the wrong section. Limited industrial. That ZBA 2 is as we've drafted it here, and ZBA 3 is now the proposed zoning article changes to non-conforming accessory structures as modified, so that Part B now just has the Roman little I, double I, and triple I.
Yeah.
Okay, so there's a motion?
Is there a
Hear a
motion?
second?
Is that a motion?
I didn't move. Okay.
I thought you moved.
I said I would accept the motion.
Oh, okay.
So
So you're sitting as chairman for the whole thing tonight? No,
That's
I'm
right.
kidding.
So,
There's been a coup.
so,
I move.
okay.
So moved.
For a second.
Second.
All in favor?
Aye.
Okay, good.
Okay, good. That's a
So
cool.
then you should accept.
I would accept the motion that we adjourn.
So moved.
Second.
All in favor? Aye.
Good.
All right.